Call the meeting to order. Are we ready back here with our webcasters? Thank you very much. And welcome everyone to our final meeting of the year for the New York State Commission on Forensic Science. Happy holidays to everyone, and I'm glad that you took time out during this difficult time to be here at our meeting. We always have a tough time because we have so many busy people here, and I appreciate that you take such a big chunk of time to be able to be here. I'm going to begin by asking, first of all, the commissioners to introduce themselves for the record. We are webcasting this meeting, so it will be available right now to those who want to view it, and also be available on the DCJS website. So let me begin with you, please.
Sure. Hi, Bart Goldart, attorney. Preston Felton.
Ann Miller, New York State Health Department.
Jim Murphy, Saratoga DA.
John Hicks.
Denise O'Donnell, DCJS. Gina Bianchi, DCJS.
Mark Monaquist from DCJS.
Okay. Chris, I guess I was starting with commissioners, but we'll just go around the table.
Oh, Chris Hammond, New York State Inspector General.
Thank you.
Harvey Van Hoven, Monroe County Public Safety Lab.
Richard Jennings, State Health Department.
Barry Scheck, Cardozo Law School.
And I'm also going to go around the room if we could, starting here to my right.
Jerry Zianski, State Police. Don Kirk, State Police.
Alan Perla, 88, Saratoga County.
Mike Nardello, BCJS. Kelsey Triangle, Inspector General's Office.
Kelly Donovan, Inspector General's Office.
Brian Fish, BCJS.
Marie Samples, New York City OCME. Kathy Dorado, Onondaga County Center for Forensic Sciences. Richard Smith, New York City OCME.
Rich Bellucci, DCJS.
Letizia Tagliaferro, DCJS.
Christopher Cheney, Yonkers PD, Forensic Lab.
Kevin Walsh, New York City Police Department.
Kate Mazzola, NYPD. Bill Pulaski, New York City Police Department.
Greg Turpin, New York City Police Department.
Tom Hickey, New York City Police Department. Scott Young, New York City Police Department, Police Law.
John Carr, DCJS.
Lacey Bernardo, Innocence Project.
Gabriel Overfield, Innocence Project.
Thank you. I'm told that we do have a quorum. Is that correct? Okay, our first item of business is to request a motion for approval of the meeting agenda, which was mailed out to you and which you have in your packet. Could I have a motion?
So moved.
A second? Any opposition? All in favor, please say aye.
Aye.
Okay, the agenda is approved. Our second item is to review and approve our minutes for our October 2nd, 2007 meeting. And they were previously sent out to the commissioners and again are in your packet. And first of all, let me ask if there are any additions or corrections to the minutes. Hearing none, could I have a motion to approve the minutes?
So moved.
Second?
Second.
Okay, any opposition? All in favor?
Aye.
Minutes are approved. We are going to have a presentation today by Dr. Berger, who is on his way from Boston, but has not yet arrived. We expect that he'll arrive in the next half hour. So we are going to table his presentation and move on. And before we do move on to our laboratory accreditation items, I just want to take a moment to make sure that you all know that John Hicks is retiring and that he will be moving on to other challenges and to really enjoy life. the process immediately to find someone who has extraordinary credentials like John to assume his position here with us at DCJS and with the Commission. So without further ado, we'll take our laboratory accreditation items, and I will turn it over to John Hicks.
Thank you, Commissioner. You have in your packet, we have 4 items actually relating to laboratory accreditation, but the first item is the Yonkers City Police Department Forensic Laboratory. You have their final inspection report and the correspondence from SBAD Lab indicating their reaccreditation by SBAD Lab. Of course, this was sent out earlier. I don't know if there are any questions about it, but our only action here would be to have a motion that that they are re-certified or reaccredited under New York State accreditation, and to act on that, to recognize their accreditation.
And that is the recommendation. They are accredited by SBAD Labs,
Yep.
correct?
Yep. The cover letter of the ASPAD indicates their reaccreditation. And there is, of course, the last page of the report there is actually a spreadsheet that Kathy Corrado prepared just to identify, I guess, the issues that were developed here. I'm not Kathy Corrado, Kathy Levine, whatever your name is. And, but yeah. And,
now we know why he's retiring.
Yeah, yeah, it's fading quickly, right? And, but anyway, that was made available just to try to condense some of the issues that came up, and there was a resolution. If there's no discussion.
Is there any discussion? Well, then, could I please have a motion to approve the accreditation for the Yonkers Police Department Forensic Science Lab?
Although I just, as a matter of, so in other words, this spreadsheet that sort of summarizes the, that was created by
Our office, and it was just
I see.
It was done for purposes of this commission to try to at least condense. If you go to the page prior to that, you'll actually see the last pages of the report. Well, it's about 2 or 3 pages prior, but you'll see you'll find the summary. It's on page 20 of the report.
No, I've read these carefully, but the reason that I raised this is that what makes a difference for me in a lot of these is that and I found this, thank you very much, Kathy, I found this spreadsheet very helpful, but what we see is, here's a criteria that, you know, they said no on an essential, here's what the auditor said, there's a proposed remediation, and then a supplemental finding. At least we get to see the last set of response.
Yes.
And I must say, so, you know, I can see what they said, what Yonkers did, so that makes sense. How much reliance should we place on, you know, I saw Nassau coming up, there is nothing in there. So, because I don't, some of these responses are not, you know, in the body of the report, but are in the spreadsheet.
Well, the Nassau and the Suffolk County issues are not really for us to act upon today, but they're just informational. This is the initial report of their inspection, so there will be remediation that they're undergoing. There'll be presumably some additional communication with the ASPAD Lab, and then ASPAD Lab will either re-inspect or accept the remediation that's provided. So there'll be another report that'll look like this Yonkers report.
But I think, like anything, this should be a guide because it's a summary that Catherine prepares, and you have the report that she calls the information from. So you know, if you have any questions about it, you should really go what's here. You're talking about what's missing.
Supplemental information, it seems. Am I wrong, Catherine? In your end document that I didn't somehow see in the report. That's all.
No, it's in the, if you saw the final audited report from Yonkers, the supplemental findings are in there, and the chart is just compiled from those supplemental findings.
All right.
And if I may, if I'm not mistaken, the supplemental findings were ultimately inspected and reported on, is that correct?
Right.
So there was a reinspection.
Right, in some cases they didn't have to go in for a re-inspection, but so ASPAD Lab would have might have taken a document.
Okay.
They went in for their inspection, and then at their remediation, they might not have had to do an additional inspection, but they were
Okay.
satisfied with the report.
So there is a motion by the superintendent, seconded by Mr. Murphy. Any further discussion? All in favor, please say aye.
Aye.
Anyone opposed? Okay, that accreditation is unanimously approved.
Okay, the next item is, also, this is informational at this point. We don't, it's not necessary that the commission act on it at this point, but you have the full assessment report for the New York Police Department Crime Laboratory. This is a very significant report in that this is only the second time, I guess, that this commission has seen this kind of report. The Westchester County Laboratory was accredited under the international program earlier this year. And so this New York, the NYPD is the second laboratory in the state actually to sort of go through this phase. So you have the full assessment report. It looks slightly different than the prior report, which is under the legacy program for ASCLD Lab. You also should have two attachments to that. One is what's called a corrective action request, which is typically generated, I guess, by the inspector or the assessor, as well as with the response from the laboratory. So it kind of provides a summary of the lab response to the issue. And then the last attachment you have, it again, is a spreadsheet that Kathy prepared, again, just to try to capture this and put it in a condensed form for you. I'd just like to comment, again, while we don't have to act on this, the significance of this. I know it was about 2 years ago, I believe, that we had John Nooner, the program manager for the international program for ASCLD Lab, came and presented to us on the what's involved in that accreditation program. But just in a nutshell, for the NYPD lab, they're going from just over 100 individual accreditation items or standards that have to be met to nearly 400 that have to be met. And in the new standards, they're all required to be met. You can't, whereas under the legacy program, you have the desired and important items in addition to the essentials. So in my view, it's a very significant undertaking and accomplishment on the part of the laboratory to have undergone this inspection done as well as it did on it.
I think that's particularly important because we have had issues, many of them have been somewhat historic with respect to the lab that we've been dealing with in the commission. And I know, speaking personally from my point of view, it's a very good and positive step forward that the lab has undergone this strenuous accreditation process under the new format and has had only very, very minor findings here that need to be corrected. So I think that's an important point to note as we have our discussion further on in our meeting today about some of the issues that have come up in the lab. So is there any other discussion about the report or any questions about the report?
Question.
Yes, Dr.
Is there an
James?
expectation that the international track will remain an option to laboratories?
It's actually the legacy program that I think is going to sort of fade out. And I think, you remember, Harvey, is it 2009 is the last date?
2009 is the last year that labs can apply for legacy inspection.
And so we would expect in the course of the next year, I know that we have at least a couple laboratories that are, the Berger County lab is coming under inspection of this program in January, and a couple of the labs will be coming about this year. So this will be over the next three years, I would imagine, that we'll see a lot of these kinds of reports coming to us.
Okay, so we'll accept the report, but do not need to take any action on it at this point.
The third item listed here on the agenda is, again, it's the initial reaccreditation inspection report from the Suffolk County Crime Laboratory, so that again, you've had an opportunity to review the findings of the inspection, and again, Kathy has summarized the findings in a spreadsheet in the back page. And while I don't know that this is necessarily complete as yet in terms of remediation, if there are any other items that may be occurring, at least it's a summary of what we know to this point in terms of their progress towards the full reaccreditation. So I would expect there'll be a follow-up inspection by ASCLD in connection with this report once they've put in place the changes that they've indicated under the remediation, and that there's been typically at least 90 days for those changes to be in effect so that the ASCLD can come back and verify that they're in place.
So this really does raise concerns about 14 of the essential criteria that were not met at the time of this review, but many of them may have been remediated as of this point or are still being remediated. Is there any discussion about the report? Yes.
I don't recall what the ASCLD threshold is for continued accreditation, percentage essential.
They have to meet 100% essential to be reaccredited, yes.
And the process then is that the laboratory receiving this report will be given an opportunity for remediation. We'll revisit, we'll make that evaluation, and if at that time there's not 100% essential, the decision is made by ASCLD after a process.
Yes. Yeah, the board would make a decision as to whether or not to reaccredit. And if they're not compliant with 100% essential, I don't believe it would reaccredit them.
Is there any concept in that interim of a laboratory being placed in a probational status, of a laboratory being placed in a, we would call it watch status, of a lab potentially in trouble? And what is the root cause? I mean, is there some funding issues, some staff turnover issues? Can the forensic science office provide technical assistance? Can you reach out to the nearest other lab? I mean, this would appear to be a terrible report. And while the lab may have said, oh, we're going to fix it, we're going to fix it, we're going to fix it, is the criminal justice system informed that this is a lab that's out of compliance and in the process of remediating? I mean, how much effort is there made to let their clients know that this is a problem? I mean, because all of these issues would seem in this interim period to raise the kind of issues that we in the past. What cases were affected, what outcomes were affected, what...
Well, I think that's if they lose their accreditation. I mean, it does raise issues. And I do think we should respond and figure out what are the root causes and what can we be doing, and what should we be doing to address them. But I don't think they're out of status from that point of view, but they do have issues, and we really, I think, need to figure out how to get to the bottom of them.
I mean, since the timing might be many months between the time surveyor informed the lab at the exit interview that there were serious deficiencies, and a ruling on the part of the board at ASCLD lab and the scheduling of a reinspection and then repeating of that process, we could be looking at a year. And then to determine, well, I'm sorry, you're still out of compliance in 3, 4, 5 of the essential. That seems like way too long. That these ASCLD lab should be asked if they're going to have some kind of an interim probationary report that places the lab on notice that this is more than a routine remediation that's required here.
Can I ask what we have done in the past? Have we run into this situation before?
Well, we have, I believe it was last year, we did have a laboratory that was placed on probation by ASCLD lab, and it was, I think, for the reasons that you've just described there.
But again, it's well into the process, and I'm just wondering whether, back to what's the commission's obligation when it has a report that's really distressing. Should we be taking a more proactive and are putting on notice that their New York State accreditation, which is based on their ASCLD accreditation, is considered to be in jeopardy?
Well, on 2 occasions that I can recall in the past, and we did, I think that again, for those kinds of reasons, we did send a letter to the agency head for the laboratory involved a letter went from the chair of the commission expressing concern about these issues and urging that they be addressed,
Should we
promptly.
do that in this instance?
I think we should.
Every situation is unique. I assume this lab was in good standing prior to the survey. This report doesn't speak at all to root cause. Was there a seminal event in this laboratory that started as decline? The fact that it's no longer doing or documenting these annual review of quality systems? I mean, there are very many serious citations in this report, but no indication of why. Have they lost half their staff? Have they lost key personnel? Has the budget been cut 50%?
I just asked, but I don't think we have anybody here from the lab, correct?
I'd like to make one point following with what Ann said, that is something I hope the Commission will take very seriously as a prospective solution. And that is what I'll characterize as a system of case tracking from the laboratory. What I do not have now is a way to move from a case that's in the lab to what happened to that case when it gets into the criminal justice system. So in other words, if we find, as we have, we saw it in New York where Dr. Puzola did, and Vince Crispino did everything they could to follow up on the Phyllis Martin fingerprinting business. But look how long it takes to go through thousands of cases. You can't hit a keystroke and go from the lab problem to the case to see what's wrong. And I really think we should take up that specific kind of prospective issue, because it's what gets in the way of going back over all these old cases when you find something that's wrong. And I think that's the point that Ann was making. I must say, as far as this lab is concerned, I didn't see any that would give rise, but the next one, I think there's some rise.
Okay, I do, sticking with this lab right now, do
Well,
agree,
just
yes.
Yeah, I'm glad that you do agree the letter should be written, but one of the things that I see here, in addition to sort of newfound problems, some of the essentials where they failed to meet muster relate to items where the laboratory had a procedure and the procedure wasn't being followed. So I don't know that, I would welcome, as Richard did, to know why this is happening. They know this is coming. This is for recertification. They know what the ASPAD lab standards are. Why is the lab falling down? Can we be of assistance in championing them on their behalf? Solicit more money from Suffolk County in this instance.
Mm-hmm.
Say, look, you can't short these people. They're not able to do what they need to do to keep you in business.
Mm-hmm.
So I would welcome a letter.
All right, well, I think if I could have a motion that the chair do a letter to the county, so this would be the county executive, and perhaps the legislature. I'll have to look at who's responsible for funding the lab, and express our concerns about the report and about their future accreditation if they don't meet all of the essential criteria that they're required to meet to remain an accredited lab in New York. And I will further talk with John about anything that we may be able to do if DCJS to meet with them and at least focus on what their issues are with our limited funding, but also expertise, and see if there's anything that we can do in that front. And we may be calling on some other lab directors to help, but I think it is crucial for the entire criminal justice system that we do obviously maintain the highest qualities in our labs, but also maintain labs around the state. We can't afford to lose them. We need to make sure that they meet the high standards that we require. So we'll do those two things. If I could have a motion, any second? Okay, any opposition to that? Further discussion? All right, all in favor?
Aye.
Okay, we'll do that.
And then the next report you have is for the Nassau County Police Department. I did see Laboratory Director Grinnell just arrived and from the laboratory. Similarly, this is the initial inspection report that identifies the issues and I guess if you want to.
There are still issues. It's
Yeah.
eight essential criteria that have not been met in the past. So it's not the same magnitude, but it's still a serious magnitude that S-Class Lab has raised a number of issues. And I don't know if the lab director wants to speak to the current state of affairs or not.
We're in the process of remediation. We're well into the process, but we're about a month shy of it right now.
Can I ask some questions about that?
Sure. Do you want to?
I mean,
Okay. Do you want to come up here? It might be
Okay,
easier
maybe
for
if
the
you
video.
Come on
view.
the corner over there. That'd be good. Thank you.
We're not putting you on the hot seat here,
no.
but I think it will help us. It will help us. Barry, I'm sure you're not intending to do that, are you?
What? No.
But I think it will help us.
No way. But I did have one question, for example, which raises this whole issue of case track. So, for example, we have here the procedures as to GSR, and if I understand this, the correction was that in the past reports would go out.
Can I make a correction there?
Sure.
One report went out.
Oh.
And that has been changed. We've notified the district attorney's office. We've made the correction on the report. We've made the correction in the procedure. We no longer utilize that statement.
Right. So I mean, so that was my question was, were there past cases?
No.
So this was just an outlier or something? Or?
This was where he's actually just the analyst had just started utilizing or wanted to utilize that statement. One case went out, and that case was reviewed by the inspectors. They didn't like the statements. They brought it to our attention. We discussed it and agreed with them. So fine, we'll change that. We notified the district attorney's office, and we made a correction in the report and sent out a supplemental report. It had not yet been involved in any adjudications at all.
And that's why it's helpful to have you here to answer some questions too, because sometimes it looks worse than it is, and we could get clarification when you're here. So I appreciate you being here in person.
That's very helpful. Because again, if that had gone out in others, we have to get them, and that's a problem. So, I noticed that there seem to be a few of these things around the prints, and I didn't quite understand. One of them was written procedures for print development. It doesn't specify the proper controls, and I took it this was procedures for enhancing prints. Was that right?
No.
So we're talking about, what was it?
Basically, they were concerned that when we reported a negative result on our fingerprint, that we did not state what we were comparing to. We did not state that in search of the New York State system, the database, that we found a negative result or no result.
Oh, no, I saw that one, but there was another one that was also related, which, except for the procedure of cyanoacrylate ester fuming, which I don't
Did it say, I'm sorry.
It says the written procedures for chemical methods for latent print development don't specify the use of appropriate controls, and the performance of appropriate controls is not documented in the case record. And I take it this is like the use of toluene and other things to enhance.
What they wanted was for us to put a control in the tank as we're processing this chemically to prove that the system, that the chemical actually works. So that if we had a negative result, it wouldn't be because it was a negative result.
Oh, so in other words, if there might have been a print there, but the machine didn't work, and that's the reason
Well,
for
if the chemical is not working,
yeah.
they wanted to know, is the chemical actually working? So by putting a positive print alongside, we would know that, yes, the chemical is actually working.
Oh, I see, that's.
And that the result that we received on the paper that we were processing one is negative.
Jim, I'm just going to cut in for a minute to the cross-examination here, and ask some kind of basic questions. If you walked in at the end of our discussion saying that it's our responsibility to make sure that the lab meets all of the essential criteria so that of Vascular Lab, so we feel comfortable with the accreditation of the lab. And when you get in this situation where you don't and you have to remediate, what is it that, is there something that we can do to support that effort, to drive home, if it is a financial issue with the lab, to the leadership in the county, how important it is that they give you the funding that you need. If you can help us address those issues, I think we're looking for guidance in that area.
In this particular case, that really doesn't have much to do with it. Basically, we would test the chemical when we first opened it up. However, we did not run a positive known alongside the test sample when we utilized the chemical.
Mm-hmm. But I'm talking overall at the essential criteria that weren't met. Are they all really technical issues that you think you can remediate relatively easily
Yes.
going forward, so it's not a structural issue that you think you're not funded well enough, or we...
Oh, no, we could always use more.
Okay.
One more along those lines, but they made a finding here about footwear comparisons and saying that the images were not suitable for comparison and the reports for illumination were not suitably documented. And these, I take it, are pictures or casts made of foot impressions?
These are foot impressions, yes, the pictures taken. And we were doing overlays. They were concerned because we do put, for a crime scene, puts a ruler in the picture when we photograph the print. And then we can utilize that as a one-to-one. Well, the rulers that we used were not certified. So because of that, they felt there might be a problem. However, what we were actually doing was an overlay of the footprint. So we would take a picture of the unknown as compared to the known and overlay it to see if we had a comparison. We have since then changed our procedures again, and we have certified rulers to utilize.
Was there ever any case where they felt that this problem was one that raised questions about the reliability of the results? Did they look at many?
I would say no, being that we've utilized overlays on all of them, and we never really utilized just measurements from that uncertified rule.
Just one observation, I in fairness to you, you just really just got this report. I mean, it's not been sitting on your desk for more than probably a month, right?
Just about.
So you haven't had a time to respond, but in terms of manpower, I was looking at the controlled substances issue, and one of them involving multiple exhibits of similar specimens, case records, often did not detail the fact that an examination was performed on each specimen. Were they performed on each specimen?
No.
Oh, okay. Again,
If we had,
is this a manpower issue? That's what I'm like.
Actually, no. We if we received the maximum charge, then we might not test each and every sample. Once we received the maximum charge, we didn't feel the necessity. However, on some of these, they felt we should have. But if we received 1,000 tablets and we tested 30 or 40 or 50 or a representative sample.
And that got you to the weight, you stopped there. That was basically it.
Yes.
Fine. Thank
So
you.
Jim, they really do sound like technical issues here. You may have said this, but how long do you think it'll take you to?
I'm hoping that by the end of January we'll be done. Only because there's vacation now coming into play.
Yeah, right.
So we have been working on this since.
Dr. Riley?
The issue we were discussing as you came in was, since Accreditation Lab requires compliance with all essential in order to be reaccredited, but clearly there are standards that are what, you know, more essential than others. I mean, that's
Yes.
not. And your guidance and the guidance of other lab directors to the commission to, I don't know, perhaps come up with a list of, you know, when do you get worried about your lab based on a survey? What are the essential standards that make you as a laboratory director immediately concerned about needing to make a major fix? What issues might present to you as a lab director that are root causes of the overall decline of lab performance and lab quality? Identifying some of those, you know, not necessarily today and not necessarily relevant to this particular inspection, might be great guidance to the commission. You know, what are the kinds of things you as a lab director, from the group of lab directors, could point out to us are the kinds of things that would be helpful for you if the commission asks the chair to send to your county executive a letter that says we're not happy with the performance of this lab, long before Accreditation lab takes away or gives final accreditation. We don't want to interfere, but on the other hand, we want to make absolutely certain that the labs are, that the county knows that we, or the municipality, whatever, knows that we take this seriously. We expect your executives who support the labs to provide you with the resources you need. The Forensic Science Office can provide some assistance, perhaps, but you know, we don't want to be doing it if it's something that was simply a technical misunderstanding that's cleared up by a statement in a mediation. But there must be some of these items that are much more serious than others.
In this particular report, there weren't, I didn't consider any of the non-compliances all that serious. There were some slight non-compliances. One instance, we had photographs of late fingerprints. Well, we had the crime scene technician had initialed and labeled it. Well, the technician in the fingerprint lab was not initialing that also. And because that went into our case file, they felt that should be initialed. We received a non-compliance because of that. It was an easy fix.
So it appears to be a serious issue to us of not failure to document an required item when apparently it's simply fixed
We
by
felt we had yes, we felt we had done sufficient documentation. They pointed out that we should do a little bit more. It was, as I call it, an easy fix. It was easy to say, yes, we will do that from now on. And
well, I guess it's an issue of how do we educate us?
their concern was if you drop the evidence on the floor, how would you be able to identify it? And we said we have a documented case number on there with the initials of the crime scene technician, so we knew exactly what that was. They were concerned that we might not be able to, so they felt that we should have the analyst in the fingerprint lab also initially.
I think the best way to educate ourselves is if we have the lab director and go through what they are and figure out the magnitude and how quickly they can be remedied. So it's been very helpful for you to have been here. So, yes.
Jim, I believe, if this is correct, that your current ASCLD 5-year period window expires on February 6th. So it's coming up very quickly.
Yes.
What do you anticipate in terms of resolving the issues in this report, and then where ASCLD can pass on that before that period ends? You anticipate that you'll complete the reaccreditation aspect with ASCLD and get their final report before February 6th? Or?
I'm anticipating that. I hope they will.
Have you communicated with ASCLD Lab?
We have been in communication with the lead inspector.
Right.
And with ASCLD Lab also.
Right. So I don't know when the next meeting of this commission may be, but I suspect it may be maybe mid-February after this expiration date. But
hopefully I have good news to you by then.
All right. Thank you very much. I appreciate it. And any other questions? Okay. All right. I'm pleased to say that Dr. Berger made it from Boston and made it through whatever obstacles the weather put in his way. but we're very fortunate to have Dr. Frederick Berger join us today. Dr. Berger is a medical geneticist at Brigham and Women's Hospital and an associate professor of pathology at Harvard Medical School in Boston. He has a very distinguished history and is a noted expert in the area of forensic aspects of DNA-based human identification. He's published countless articles, testified as an expert witness in many, many state, federal, and military courts in the U.S. and abroad. He's been a prolific writer and scholar in many areas involving DNA-based human identification. I should say by way of background that we have asked the DNA subcommittee to look at various aspects of familial DNA examinations, partial identifications, familial identifications, understanding the difference between them, and giving us some advice on the future direction that the commission should take in that regard. We did receive some urgent communications saying don't go too quickly, but I want to assure everyone on the commission that there's no plans to move too quickly. I do think it's an important agenda item for us this year, next year, going forward. And we have asked our DNA subcommittee to conduct a meeting and symposium on this area, which is scheduled for January 15th in New York City, that we can discuss further. But we thought a good start would be to bring a national expert with Dr. Berger's expertise here to speak to us about these issues and to sort of lay the groundwork for us to explore further into these areas. So I appreciate you making the trip here, Dr. Berger, and I'd like to turn it over to you.
Thank you, Judge O'Donnell, and thank you, Mr. Hicks, for inviting me. Pleasure to see some of my familiar friends' faces here. And I wonder if the lights are low enough for those of you in the rear to see the slides. Well, John actually asked me to focus my comments today and to be reasonably brief, which I will be. And the commissioners have a handout of all my slides, so you won't have to take any notes. But I'd welcome questions per your protocol during the talk. If you want to interrupt me, it won't be a problem. This area of the proxy identification of potential criminal suspects using the kin, the DNA of kin, is not a new idea. It's been around for a while, and as you know, most methods of law enforcement investigation may involve use of partial evidence, whether it's a partial license plate or partial description of a suspect, whether it is regard to his age, his suspected race or ethnicity or biogeographic ancestry, the type of clothing, the type of car. Those of you who are experienced investigators know much better than I how you use partial information to get new investigative leads. The DNA helix that we inherit from our parents is no different in that those of us who share blood relationship through close family ties share parts of our genome, sometimes all of it if we have an identical twin. And this makes the DNA molecule also a potential investigative tool, not just for perfect matches between crime scene evidence and a suspect or group of suspects, but they're close kin as well. And we all have had, I'm sure you've had experiences as I have, where there is a perfect DNA match between crime scene evidence and an individual who may be identified by coincidence or through search of a DNA database like the one you have in the state of New York. And it may turn out on further investigation that that person for whom there's a complete DNA match could not have committed the crime or couldn't have been involved because he was deceased at the time the crime was committed,
or he was incarcerated, perhaps in a prison or jail or some other institutional confinement setting. And even the first-year biology students at our school in Cambridge could say he must have an identical twin or a triplet. And in fact, those cases have happened all the time, and I'm not aware of a single instance where you would hesitate and say, well, there are probable cause issues or constitutional issues or statutory issues that would prevent you from investigating that obvious lead. And so part of my rhetorical question to audiences like this, when I am asked to talk about this, is if you would go after the identical twin, that because you identified his co-twin through a database search or a one-off comparison because he volunteered a sample, then why wouldn't you use that information to go after a potential suspect who may be a brother, a non-twin brother, or a father, or a son? So we'll move through this talk. I think that the late federal judge, Learned Hand, made a comment in one of his early writings that echoes for me. He talked about the justice system in America being pulled by a three-horse chariot. One of those horses representing the law, one representing medicine and science and technology, and the third horse representing ethics and morality. And he wrote, better than I could speak about it, that sometimes science and technology raced ahead of the other two horses and made for a rocky ride in the justice system. I think we may be seeing an example of that in the power of DNA technology and the potential power of proxy searching. Maybe this one horse drawing this chariot of justice is running faster than the other two horses can run. And we'll see what happens. We're going to talk primarily, therefore, about indirect identifications using DNA. Not a perfect match we're all comfortable with and we've seen many times in the courts, both to exonerate and to potentially implicate. Indirect identifications are widely used. They've been used for dozens of years in paternity testing. Sometimes we have a motherless case. Sometimes we're questioning whether the father is a potential biological father of a child for civil or criminal investigations. We use so-called reverse paternity testing when we find human remains at 9/11 from the Pentagon, from Shanksville, Pennsylvania, or the Twin Towers, and ask, could these human remains belong to Mr. and Mrs. Smith? In New York's State Police and the Medical Examiner's Office in New York use these indirect methods to identify literally hundreds of individuals through these indirect methods, and you're familiar with them. And we're going to focus this morning, of course, on the third aspect here, the potential use of these same methods. They're no different than those that are used all the time in humanitarian rescue efforts. And they basically ask variants of this following question. Is there a biological relationship or not between individuals in an imaginary pedigree? In this case, the father, the yellow father, the red mother, and the gray child, the F, M, and C in the standard pedigree, where circles are females and squares are males, for those of you who are geneticists. So this question is asked all the time in a variety of ways. Could this child belong to these two parents? Is this named man the biological father of that child? Is this mother the biological mother of this child? We just had a case last week in an unnamed state and city where a baby was buried in the wrong grave. And a baby was buried in the wrong grave, and there was a body left over, and we had to demonstrate whether that baby belonged to the mother so that she could put her true baby to rest before Christmas, which was their dream and hope. And so these methods are used for a variety of situations: hospital sample mix-ups, etc., estate issues, immigration, child custody. So again, a lot of the methods that would potentially be used in forensic investigations are well known in the forensic community, they're well known in the genetics community, and the math and statistics. So it doesn't involve new techniques or methods, but simply different uses of those existing techniques and methods. And of course, they're needed when relatives may have to come forward, as they did at 9/11, and the Becky Prince and her team in New York collected and gathered those relatives, brothers, sisters, husbands, wives, children, grandparents, uncles, cousins, etc., who came forward with this result. And those of you who've read the paper that was published by the team will read that of the 2,748 reported missing after the Twin Tower attack, about 1,600 were identified, half of those by DNA testing of various types, and about a quarter of all the genetic-based identifications from the Twin Tower attack involved these indirect family kinship analyses, what we call kinship analyses. So it became not just sufficient but necessary in a large number of cases. In Katrina, that I was also involved in as part of the mathematical group that assisted, in this case, the Louisiana State Police, and in some cases the U.S. Army, to identify individuals who were lost in Katrina and Rita. Most of the DNA-based identifications required kinship analysis, this indirect method with the relatives coming forward to give their samples, in part because any kind of hospital biopsy samples or toothbrushes or personal effects that may have been left behind were, of course, washed away in the dreadful floods and wind that occurred. So kinship analysis sometimes is only used when necessary, sometimes it's the preferred method as it needed to be Katrina identifications. If we move ahead to forensic investigations, I want to give you two quick examples of using kin in an obvious way. Neither of them involve a database search at this point. And you know, I'm sure, about the Wichita, Kansas investigation of the so-called BTK serial killer investigation. BTK was the name he gave himself for find, torture, and kill about a dozen victims over a 10-year period that went unsolved. And finally, the Kansas Bureau of Investigation and the Federal Bureau of Investigation identified a man whose image is displayed here, Dennis Rader, who was a key suspect in this crime because of a computer disk that he thankfully sent the police to taunt them about the next crime he was going to commit. So they identified him as a potential suspect, and of course, those of you who've done investigations know better than I that the last person you want to know that is a suspect is the suspect. They didn't want to go try to find a cigarette butt or coffee cup from Rader to compare his DNA to the semen evidence at these crimes that all matched, so they knew they were dealing with a single serial perpetrator. They knew he had a daughter, a biological daughter from his marriage, and that she had recently had some GYN exam, as any girl in this country over about 18 years is offered regular Pap tests. And as you know, we in pathology, we keep any biopsies forever. We don't throw things out. And they got a court order, a valid court order, and this is one of the exceptions to HIPAA privacy issues, that in certain instances, law enforcement can get a court order for a hospital to turn over without this daughter's knowledge or consent. She lived in another state at the time. They extracted DNA from the hospital biopsy specimen and did a reverse paternity test, basically asking the question, could the owner of this Pap smear DNA be the biological daughter of the semen donor from these serial crimes? The answer was a resounding yes, with a high likelihood ratio. That's a mathematical formulation. And based on that and other evidence that they had gathered, they, referring to the KBI, the Kansas Bureau of Investigation, and the FBI, made an arrest. And as you know, this man confessed to those crimes and was sentenced. So this is a dramatic use of proxy DNA to investigate a series of crimes. Timely, just yesterday, December 19th, just yesterday in the remote area of Kingfield, Maine, police have arrested a 44-year-old, and they had him as a suspect for years in this brutal torture and murder of a young boy. And they actually linked his DNA to the crime scene through his sister before making the arrest. This is just in yesterday's Associated Press release. So these kinds of one-off comparisons where you have a suspect in mind, but for reasons that you investigators know far better than I, don't want to approach him, it's usually a him, one can go to a close relative and compare the DNA. Could these two people be related? The owner of crime scene evidence and the person who you can get a sample from. Either a voluntary sample, as they did in this case here with the sister, or an unknown non-voluntary sample through court order, through hospital records. So these methods are used, and you may know of cases, or you may have done cases yourself, where these methods have been happened, or have been used. Again, just to be complete, when these samples are taken and the DNA profiles are obtained by the lab in the normal methods widely used, typically using the STRs, the short tandem repeats, and multiple genetic locations, loci, a so-called paternity index or a kinship index, depending on the type of relationship, is computed. And these indices are simply a ratio of two competing probabilities, shown here in its simplest form. In the numerator, the probability that the named man is a biological father, given the genotypes in question, and in the denominator, given those genotypes, what's the chance that a random man, randomly selected, could be the father by chance. And of course, the strength of this ratio depends on how large the numerator is in relation to the denominator. Typically in these ratios, the one we computed recently on the mixed-up baby was about 200,000 to 1 in favor of that genetic relationship. And so statisticians and crime labs have to decide amongst themselves what will be a likelihood ratio that will tip the scale for them to avoid making mistakes. Okay, let's talk for a moment then about relatives and how many genes they share in common. And we'll talk specifically about the 13 loci that are currently used in the United States. Other countries are using more than 13 in some cases, and there's a lot of activity going on with regard to a whole new set of genetic profiles using what we call SNPs, single nucleotide polymorphisms, that we won't touch on but briefly today. If you modeled based on allele frequencies in the human population, take any population you want, whether it's Asian, African, European Caucasian, Southeast Hispanics, etc. When you model this, you would predict that on average, true siblings, that is brother-sister or two sisters, would share on average more alleles in common by virtue of common ancestry than would unrelated people. And you can model it as we did, or you could take real data, which we also collected. When I say we, I'm referring in this slide to a work that we did with the Connecticut State Police Forensic Science Lab in Meriden, Connecticut, with Drs. Michael Burke and Carl Ladd. And these data come from sampling a couple hundred groups of individuals, those who are known full sibs and multi-generation kinships, and unrelated volunteers with human subjects' approval. And we simply type their 13 locus STR profiles, as you would crime scene evidence. And we, of course, anonymize these samples so we can't go back and identify any of those individuals in particular. We found on average, I just want you to focus on the number of alleles shared, because if we're typing 13 loci, 13 different genetic locations, and we get half of our genes from mom and half from dad, we're going to have 26 alleles in our profile. 26, 13 from mom, 13 from dad. You can see that on average, true siblings share on average twice as many alleles in common across the whole profile as do unrelated people. This is just what the statistical modeling would predict, about twice as many for sibs. So because any allele you get from dad, the number 11 allele at the TPOX locus, for example, the chance that you get that your sib gets that is 50-50. Either gives that or a different one. So it makes sense in a way that you see this level of difference. What was interesting, yes, Mary?
How did you get the SIBs and the unrelated pairs in terms of racial and geographic makeup?
These were all volunteers from Connecticut and Cambridge, Mass. Harvard students. They're not. They aren't segregated by race or ethnicity. They're just volunteers, college kids and people who work in the crime lab. But when you model this, Barry, you can use the data from any ethnic group, any of the so-called ethnic groups, and the predictions would be the same. What was interesting about this is we found one pair of SIBs. You can see the 9 here. This pointer works. The 9 here refers to the fact that we found one pair of SIBs that were identical at 9 of the 13 loci. They had the identical profile. This is important, and I'll digress for a moment for 2 reasons. One is that if you have degraded evidence from a crime scene and you find a 7 or 6 locus match, you can still get a fairly sobering statistic. But you better be darn sure, excuse my French, that it's not a brother involved, for example, because you could have an adventitious match on a 6 or even 7 loci, and because the sample, the crime scene sample is degraded, you're only comparing part of the profile, and it could be one of his close relatives is a true perpetrator, and you could make false arrests. Cases like this in Texas where they're seeking the death penalty, partial DNA evidence, and I've instructed the Attorney General's office there that they really have to round up the brothers, if there are any, or close relatives, and exclude them before they go forward. They've usually done that because they're aware of this potential issue. On the other hand, a close but not perfect match also raises the flags that this could be dealing with a close relative. So the sword has 2 edges, and it's important in investigations to use it thoughtfully both ways. But the only point of this slide is just to demonstrate to you with real data what we already would predict from population genetics, that close relatives will share more of their genotype in common. Yes, John?
Just a comment too, that while you mentioned that with 13 loci you'd expect to see 26 alleles, in fact you may not see 26, you may have homozygosity at some loci.
We have 26 alleles, some of them may be the same at one locus, so you may not have 26 different alleles.
Yes.
But you do have 26 alleles. They may not be the same. Absolutely. Moving to the concept of data banks. So we've all agreed that we can identify suspects directly or indirectly with one-off comparisons. What about data banks? Well, these data come from the FBI site. As of October 07, you have about 200,000 offender profiles and so on in the data bank, but the national NDIS, of course, has over 5 million now in the U.S., which is almost as large as the UK system. The UK has about 6 million plus samples now, even though their population is considerably smaller than that of the U.S. And these the laws, the statutes in all the 50 states that empower the government to collect DNA from various categories of individuals who've had collisions with law enforcement were intended to aid in criminal investigations. Some of the critiques we have heard about the use of family searching say, well, gee, it wasn't the statutory intent to identify the brother or father. Well, none of the statutes directly address this. Certainly, when you read the statutes carefully, which we have, there are 2 ways to look at this. You can't do something unless the statute says you can, or you can do anything you want if the statute doesn't prohibit it. I haven't been to 5 minutes of law school, so I won't say any more about how you attorneys interpret statutory intent and the original purpose, but I happen to be directly involved in the discussions in Massachusetts and testified in support of DNA data banking legislation in the Commonwealth, along with Don Herkenham, an attorney then with the FBI, and Reed Hillman, then the colonel of the state police. So I was directly involved in drafting the legislation that eventually passed. In fact, I submitted 2 bills as a private citizen years before. In Mass, private citizens can submit bills, and they never made it out of committee. until I got the sheriff of Middlesex County to co-sign it. Anyway, so I do have firsthand appreciation for and understand what the statutory intent was, even though none of the laws that exist currently mention family searching. Certainly the purpose of these data banks was to aid in bringing true criminals to justice.
Are you saying that when you testified at that time, it was anticipated that the databases would be used for anything other than direct hits?
We didn't discuss that, Barry, but we certainly were aware of the concerns about using the DNA sample for medical inquiries, like determining the disease status of an individual. And most of the prohibitions and sanctions, as you know, relate to misuse of the data with regard to finding that someone's a carrier for sickle cell anemia, or using it for research in a non-qualifying way. Some of the statutes allow it to be used for population genetic data gathering, so you can use it for allele frequency determinations, or other I think our bill reads other humanitarian purposes. We were trying to conceive of other situations where we might want to know that offender's profile or interrogate it for a humanitarian purpose, to identify his mother who drowned in a boat or something. So we made when I say we, I will accept part responsibility or credit, whichever the case may be, for the bill that's passed in the Commonwealth. But to directly answer your question, we didn't discuss familial searching, but I'm a geneticist and have been thinking about this far before the bill ever was put forth. But why do we need to get bogged down in that?
Well, no, only because you were making a suggestion about what the intent of the drafters were. And since we were all around then, we were all discussing these issues, my recollection is that when all these bills were passed, as you indicated, there were very strict exceptions for when you can get access to this data for humanitarian purposes, for population genetics research, but there was no question that the term forensic identification purposes were applying missing people to link individuals who were designated by the state to be in an offender database to unknown crime scene samples. And everybody was talking about direct hits. Nobody was talking about proxy searches or kinship.
The statutes don't even define what a match means. Is a match a partial match? Is a match a complete match? And those are covered in CODIS regs that the ANDIS board discusses and that each state machinates over themselves. But none of the statutes directly define what a hit means, or what a so-called match means. Does it mean a 13 focus match?
I'm a little concerned about hearing you say, because so far everything you said is, been obvious, and paternity tests and all these things are plainly true. But the notion that any of us that were testifying in favor of DNA data bank legislation, of which I was one, and wrote about this, ever was suggesting to any legislator that when they passed that bill for the data bank, that it was even contemplated or suggested out loud that that would be searched for close relatives.
Well, I'm just gonna interrupt, because unless we know you're gonna get through your presentation, I think we should have the legal discussion at another day.
But I'm only want to make one point factually, and that is, that was never said or discussed to the legislature, regardless of what you had in your mind. Isn't that right?
Absolutely.
Okay, let's just be clear about that. That's a fact. I don't want any suggestions to the contrary, because everybody passed these statutes with something in mind.
Just a brief comment, Barry, and I was just looking back through the minutes of this commission meeting, just very brief review in the last few days, and I found that I think it was 1997 or 98, a discussion about the rulemaking to allow as few as 6 loci, for example, or as few as 4 loci to be searched against our data bank. And during that discussion, at least the minutes reflect that there was discussion about the likelihood that you may find familial relationships. It's reflected in the minutes. I wasn't here then, so I'm hoping that, I think you were both at the meeting, Dr. Willie and Barry, but maybe you can recall those conversations.
No, of course, but that's a different discussion. I just want to make one point clear, because I think Fred would agree with me as we go down this road of the discussion. When these statutes were passed, right, while all geneticists knew you could do this, and it's done all the time for paternity testing and for immigration purposes and everything else. Nobody was saying to the state legislators, we're now passing a bill where you're going to create a data bank of convicted offenders, and we can search that not just for the individual, but we'll be able to go find their relatives, their brothers, their fathers. Nobody was saying that to these people. That was not what was being presented.
Okay, this record will report that is your view at that.
Well, no, but
time,
it should
so-
also record that Fred agrees, even though he had it in his mind, it was not presented that way in Massachusetts, New York, or anywhere else that we know of.
I don't know about that, but
Well,
continue
you know
with your.
about that, Denise, and if we're gonna get to the bottom of this and be fair about it, that's the case. I'm not, forget the merits. I mean, people may want to change their minds or anything else.
Well, Barry-
That's not how it's presented.
No, but we're not discussing the legality of it right now. We're learning the process. And
No,
I think we will have plenty of time to discuss whether we should do this in New York or whether it was contemplated at the time that the data bank was set up.
Well, it's the last point, Denise. We're just talking a factual record, and I'm sure Fred would agree. Nobody said that to these legislators. That was not the premise upon which the bill was passed.
The premise upon which these bills was passed was just as we both agreed, Barry, and that is to aid in criminal investigations. How that's done, I don't know what was in the minds of everyone in the 50 states. Okay, let's talk about data mining, what some have called data mining, how to make more use of data other than looking for the low-lying fruit, that being the perfect 13 locus match. And there are a number of methods that have been discussed and described in cases that have been successful. Some using kinship analysis, some looking for rare alleles, some simply counting alleles, as they do in Britain now. We'll talk about that briefly. I want to just talk about a couple quick cases so you're familiar with the spectrum of things that has already gone on around the world and in the United States. In this investigation of the stabbing death of Lynette White, 3 individuals were convicted of this crime. 5 were initially charged. 3 were convicted. They were known then at the time as the Cardiff 3. Their convictions were quashed because of problems with the investigation and the nature of the evidence. After their conviction, they were overturned. The crime lab at the time had access to the modern PCR-based DNA methods. They went back to the crime scene, literally took the kickboards off the wall, got about 900 DNA samples, most of which matched Lynette, but some did not. They searched for the male profile that didn't match the victim against their database and found no match. At the time, their database had about 600,000 convicted offenders. They screened 300 people who volunteered their samples in a DNA dragnet in the Cardiff, Wales area and found no match, no perfect match. Andrew McDonald, shown in the lower right, noted a rare allele at one locus. This is an amazing case. And what I love cars, so I tell my students that he was looking for that yellow Ferrari that we'd all mentioned going down Main Street in Albany, but none of us would pay one whit's attention to the white van. So he was looking for that rare event that occurred in this profile. They then narrowed the search in the UK from 600 samples that had this rare allele to 70 in the Cardiff, Wales area, and then they looked at the whole profile, looking just at samples that shared that rare allele in common with crime scene evidence, not from the victim, but from the proposed perpetrator. And one sample stood out from a 14-year-old who wasn't even alive at the time the crime was committed. He had gotten himself into the UK data bank for a car violation. And his father was excluded. His father volunteered a sample when the constables arrived at his door. And it turned out, they asked, did he have any other close male relatives? He had an uncle who had actually been a part-time police officer who confessed to the murder. Jeffrey Gafour confessed to the murder of Lynette White. Again, this is called the database search, focusing on a single rare allele at one locus. An astounding, fortuitous event. Let's talk about DNA registries, including the one that you have in New York State, the one we have in Massachusetts. We, the editorial we in society, are collecting lots of samples from people all the time. Mass disaster samples, research samples. Those of us in the military have a DNA blood spot card in Rockville, Maryland. They now have over 5 million of these blood spot cards from soldiers, sailors, Marines, and airmen. Voluntary samples, and I would argue we have proxy samples in these data banks. You already agreed with me that identical twins have the same virtual profile that the co-twin has. So if we have twin A, the bad guy, the evil twin in the data bank, we also have his Eagle Scout brother, twin brother in the data bank, even though his literal sample isn't there, his virtual DNA profile is there. So we also have the close relatives accessible within your reach if you choose at some point in the future to consider using proxy profiles, as you already do for identical twins. And this is all that I'm asking you to consider. I'm not an advocate for this necessarily. I believe in bringing crime perpetrators to justice by any reasonable means necessary within our Constitution. But look, I wanted just to compare mass disaster, concept of mass disasters to crime scene investigations. We have volunteer relatives coming forward to help identify by proxy human remains that they wish to take back to the funeral home. And the rhetorical question is that could we use the potential relatives in the offender index to identify heretofore unidentified potential criminal suspects? Again, underscoring, for those of you who might wonder, I don't think for a minute that finding DNA at a crime scene necessarily tells you how it got there and when, nor is it prima facie evidence of guilt. So given that caveat, the analogy, I think, is a correct one. I'm not saying that you want to do it, Barry, but I'm saying that you can use the offender index in the same way we use volunteers to identify them.
But wouldn't the correct Miller analogy here be we could create a data bank of volunteers? In other words, the whole communities could volunteer their DNA and put it in a data bank in the effort to find unidentified suspects. If my cousin or brother is potentially a criminal, but I know I won't commit a crime, I'll put my DNA in the data bank, and that will assist in finding unidentified suspects. That's why the relatives are volunteering to put their DNA in because they want to identify human remains.
Yes.
Right? For people in your database.
Well, the one difference is that the people in the offender index didn't volunteer to have their sample.
That's a big difference.
They qualified.
Right, and their relatives didn't volunteer to have their DNA accessed and their...
Most criminals that I've met haven't volunteered to be caught.
Not talking about searching for the criminals here. We're talking about searching the guys, right?
Right. We're searching. We're talking about searching the offender index for close matches to crime scene evidence.
Solve crime.
Right.
All right.
So three of us, Charles Brenner and David Lazar, who some of you know. Charles is a mathematician in California. David is a policy wonk at the Kennedy School of Government in Cambridge. We wrote a paper that you have as one of your handouts, and I'll be brief. We simulated how successful these methods, the more sophisticated methods, what we call kinship analysis, how easy would it be to shake this CODIS tree and find relatives who are in the data bank who didn't commit the crime themselves, but they're closely related to someone who did commit it. Would this be efficient? It requires a lot of assumptions about what proportion of individuals who are offenders have a close relative who's also an offender, and a number of other things that are explained in the paper. But the bottom line that I would like you to just focus on is based on our simulations. Again, they're simulations, but they make realistic assumptions. And depending on how many leads you would want to investigate, you'd have a fairly high chance, this is a percentage, so it's 0.6 and 60%, you'd have between a 40 and 60% chance, actually 60 to 80% chance, if you looked at the top 10 leads, if you rank ordered every offender in the New York State database in order of decreasing likelihood of being related to the blood spot outside the bank property, you would have a very good chance of finding the true perpetrator, the kid of that individual, looking at only 10 leads, assuming that his brother is in CODIS, right? There's a big assumption there, and we factor that in to the calculations in this paper. This would be an arcane discussion if every criminal's brother was the Eagle Scout. Then this would be armchair statistics. The sad reality, that again, that you know much better than I, the sad reality is that the so-called apple often doesn't fall far from the tree for lots of reasons. Organized gangs, dysfunctional families, crime families, and syndicates that often involve close relatives. I'm not making a statement about why that is, it's simply the reality. When we've asked criminologists, and we are not criminologists, when we've asked criminologists to help us understand this on a sociological level, they point to data like this from the Bureau of Justice Statistics in 1996 that finds that 40 to 50% of jail inmates have a close relative who's also had a collision with law enforcement at some point. Most commonly brothers, 30% of them have a brother who has also been in the criminal justice system. So that's why when we talk about relatives, we're usually talking about brothers, but not always. And there are other data like this that you are familiar with. I want to say something about false positives because any method of investigation, including DNA testing, could lead to the identification or the knocking on doors of people who are completely uninvolved, but who share a lot of alleles in common by chance. Barry and I, even though I don't think we're brothers, we could share. We could be identical at 2 or 3 loci. We could share 6 or 8 alleles in common in our profiles, even though we don't come from immediately common ancestors, although we're all technically related from the out of Africa migration. Depending on how you want to work your statistics in these simulations, you can calculate how many false leads you need for every true lead. And depending on how you titrate the analysis and how your law enforcement agencies decide to behave in these investigations, you could either have a lot of false leads or fewer false leads, depending on how wide you want to expand that net, how much filtering you want to do.
I'm very confused by what do you mean by a lead or false lead? What are you saying?
A lead being the identification of a person in the data bank who could be closely related to the crime scene evidence. He's not the perpetrator himself, but he may be close related because of the high kinship score.
But that, you're defining this as, what about cousins?
Right. Finding cousins would be hard through this method. Unless we get into Y chromosome, we'll talk about that. But we're talking about brother, sister, 2 brothers, brother, sister, or parent-child in these particular analyses. What we call first-degree relatives. And this is just the false positive issue for parent-child. It's worse for siblings in terms of the statistical power.
That's parent-child.
Yeah, that's parent-child.
So how many false leads would you have if you're siblings?
And you probably have 2 or 3 times that many.
Right.
So parents have to share half their genes with their children because they give them the sperm or the egg. 2 brothers could share both alleles on a locus, only one or none, depending on Mendel's laws. So the situation is potentially worse if you just use the mathematical approach. How do the Brits, who've already been doing this for a number of years now, how do they do this to find this so-called needle in the haystack? They do 2 obvious things, and you've heard about one of them in the case of the murder of Lynette White. They used geography because most crimes, we're told, occur within a few kilometers of the domicile of the perpetrator. So they'll search on high likelihood ratio scores or high allele sharing in the Albany, New York area or Saratoga. They won't be looking at Clearwater, Florida or Jacksonville, Florida when they're narrowing this search. And you saw how they did in the White case. They narrowed the number of leads from 600 to 60 just using geography. The other powerful tool that you already have available is the Y chromosome, because it's inherited as a unit, transmitted from father to son. And if you screen samples for Y chromosome markers, you can eliminate all but a handful of non-patrilineally related males. So what others have proposed is that you could get a laundry list of samples that share close allele counts or high likelihood ratio. You could winnow those out with geography and winnow most of them out with the Y chromosome. And this pedigree simply shows you how all the square males in this family could be separated easily by the Y markers, which would separate the blue males from the red ones, since fathers send their Y chromosome directly to their sons and grandsons unchanged by crossing over. I'm near the end of my comments. I'm going to talk now less about the science than about some of the policy issues that have been discussed in the groups that Barry and I and others in this room have been part of already. Is this slippery slope, or is this a new tool in your toolbox to bring perpetrators to justice? I mentioned earlier in my comments that you're used to using partial evidence all the time. Who in their right mind would suggest that the local state police would ignore a partial license plate if they had it? You didn't have the perfect license plate match, so we're going to ignore it. And I'm not aware of any other type of forensic evidence where less than a perfect match is simply ignored. I know there are some differences between license plates and DNA, but you can even, as you know, you can even order information about the holder of a license plate from a partial plate. So this concept of using partial evidence and even searching a data bank for it is, this isn't even confidential in some states. You can pay the Registry of Motor Vehicles in Massachusetts $5 and find out my address. But the only point in these slides is to indicate that partial information can be terribly useful. Some of the opportunities, I hope, are self-evident. You could, as Britain has now done in over 100 cases, they've used family searching methods, usually by allele counting and geography and Y screening, sometimes mitochondrial screening to look at maternal lineages. They've solved about 17 important crimes so far out of about 150 that they've attempted on. And there are cases that I'll show you about where they help exonerate the innocent. Are there Fourth Amendment issues? That's for the courts in this country to decide, but as you know, when the DNA databases themselves have been challenged, the courts have not found those arguments compelling. Some have asked, again, we talked about statutory intent, but if there are in fact constitutional issues here, then it doesn't matter what the statutory intent is, because the courts would have ruled that databases on their face violate certain rights we have under our Constitution. Are court challenges likely? Sure. Can the police demand to see the data? One of our colleagues, Brock Harmon, gets his dander up when he worries about labs having a close but not perfect match from a DNA database search and them not even telling the police. Do the police have a right to have this information, even partial information, as part of their investigation? I can't answer that question, but it's one that's out there in the community. Shouldn't the police be able to talk to the laboratorians and say, well, you don't have a 13 locus match, could you look for a 12 or an 11 or a 10? help us. Maybe it's a brother. When I talk to small-town police officers in rural New Hampshire, where I spend my weekends, they say, Fred, you guys at Harvard think you're so smart because you're doing these fancy statistical things. We target families all the time in the town in 2000 that I live in, and we know what brothers are doing car stereo thefts. So we know it wasn't Jim, it was his older brother Billy. We're doing family searching already. It's called good old-fashioned police work, where community policing often gets to know the families. So this business of looking into families and knowing about family relationships has happened by good old-fashioned cops and detectives far before DNA came onto the scene. The other issue that we should confront and address square on is the issue of racial and ethnic disparity. These are just snippets of data that you're probably familiar with. It's true in Britain, it's true in the U.S., that there are disparities. We argue about this word in our paper. We use the word disparity. Some reviewers suggested we use the word inequity. And we weren't happy with that because we're not sociologists or experts on criminal investigations. What the reasons for this disparity are something for another day and another audience or another speaker. But the question has been raised is if family searching were to be instituted, certainly on a wide-scale basis, and no one has advocated that. We're talking about using it when you're in the bottom of the ninth for 2 hours, when you've exhausted other leads and you need some extra tools to help you. But the point is, if it were used on a wide-scale basis, would it unfairly target certain biogeographic groups unfairly? Would it put more of the black community or the Hispanic community under lifelong genetic surveillance because by proxy searching we could identify SIBs? So this issue is out there. We could probably talk about that for 2 hours. But,
I just want to comment that the broader you have the capacity to take DNA from others, not just from prison-eligible people, that the less the racial disparity will become an issue right now, since these are prison numbers, correct? So, I mean, if we were to have an all-crimes DNA bank here in New York that really could take DNA at any fingerprintable offense, that would lessen the racial impact.
And we'll talk about this because, as you know, David Kay, the law professor at Arizona State, and his colleague Michael Smith have written articles suggesting that a nationwide database should occur. But I personally don't agree with them, but that discussion has been out there. Could it intrude on the privacy of those who are adventitiously identified? And this point here on the right gets back to the false positive issue. How many wrong doors would we have to knock on, or God forbid, kick down before we found the real perpetrator of those crimes? And what rights do those individuals have who haven't been individually suspected of any crime? And this raises issues in some mind of probable cause. And would those issues outweigh society's expectations for public safety in the instant case? Okay, I'll summarize what I've already said, and then I have 2 quick examples for you. I would argue that male kin are in CODIS by proxy. Their identical twins are in there. We've already agreed on that. I've seen some of your heads nodding. And I will argue that their other male relatives are in there as well. They share the same Y chromosome. They share a large proportion of the rest of their genome. These methods are technically feasible. They're not instantly doable using kinship with the software that you have in the CODIS system. The new generation, I think they're going to call it CODIS NG, CODIS Next Generation, will have kinship tools in it designed for humanitarian purposes. Whether or not the Endus board that Tom Callahan runs will put holy water over this idea is anyone's guess. But these software upgrades and other software programs are out there. Charles Brenner has written one called DNA View that many crime labs use. The software isn't unreachable by any agency that would care to use it for this purpose. Let's talk very quickly in my closing comments about one quick case, and it involves the use of family searching to actually exonerate someone. I want to emphasize this case because I think it's so troubling. Darrell Hunt was convicted in court for the rape murder of Diane Sykes, even though his semen blood type, he was a secretor, his semen blood type didn't match, or his blood type didn't match the semen blood type obtained at the autopsy from the newspaper reporter Diane Sykes. He was granted a new trial because some witnesses later recanted their statement. He was offered a plea for time served after 4 years, and he refused. He said, "I didn't do the crime." He was retried again and reconvicted 5 years later. Some of you know this story because it was displayed, among other places, on 60 Minutes. In 1994, they finally had the new methods available. They did DNA testing and compared Darrell Hunt's DNA sample from his blood cells to the DNA from the rape murder of the victim, and it didn't match. The state then argued that he had another assistant. The court agreed, and he remained in prison. 37 different state and federal judges reviewed his file over the years. They turned down his appeals, and 2 governors refused to act on clemency petitions. So that's the story of Darrell Hunt. Finally, the Winston-Salem newspaper wrote an 8-part series about this case. And the Bureau of Investigation ran the DNA against POTUS in North Carolina. They found no match. They did, and in fact, they couldn't get a result. They got only a partial result. They sent this crime scene sample down to Angelo Delamana, now and then in Alabama, and he got a perfect 13 locus profile, and again, still no match with anyone in the crime scene, in the offender index in North Carolina. But they noted one sample belonging to an Anthony Brown, where 20 of 26 alleles were shared in common. He had 11 brothers. They did the old-fashioned police work that you're familiar with. 6 of those brothers were dead, but one of them was being held locally on a misdemeanor charge. They offered him a cigarette. He smoked it. They got the 13 locus profile, and it was a perfect match, and he confessed. And only then, only after they found the real perpetrator of this crime by family searching, was Darrell Hunt exonerated, thanks to the efforts of Innocence Project attorneys and others, and finally received a real pardon of innocence by the governor in 2004. 19 years in custody. He'd still be there today if it weren't for family searching that they did purposefully in this case. What I think, I have 2 closing slides. I think what we need to do as a group is avoid what those in the military call incestuous amplification, where a reinforced set of beliefs among like-minded people often lead to making their preconceived ideas more extreme than they were, one way or another. And I'm very much aware of this, and as an academic, try to remain as neutral as I can be. And I think that I applaud your committee and your commission for wrestling with this issue. I think we have wrestled with it in Virginia, where I'm a member of a similar body like this was appointed by the governor of Virginia. And before our committee took this issue up in Virginia, under the great leadership of Paul Ferrara, who's now retired, if they found a close match between a one-off comparison, not even talking about databases here, if they found a close match between crime scene evidence and someone who they had a voluntary sample for, a suspect, a voluntary sample where they got a cigarette butt, it didn't match him, but it was really, really close. They weren't even telling the investigator because they were worried somehow that this would violate some principle. Our committee, with a similar constitution to yours, were quite shocked, actually, and we said go forward with all steam. And then that went up to the higher board that reports directly to the governor, and they put holy water over our recommendation, and now they are freely giving the detectives in the Virginia State Police that information. They have stopped short, or we, the editorial, have stopped short of advocating family searching on a purposeful basis at this point, because we don't think we have the tools available We're trying to learn from the Brits, who've had a lot of experience with several hundred cases. New Zealand, Australia are using these methods. Germany will probably start. That is neither here nor there. But I think that these conversations are important to have, and how we weigh the competing interests of public safety and personal privacy is, I think, the challenge that all of us who care about freedom in America think about all the time. Thank you very much.
Thank you.
Can I ask you a question?
Of course.
Obviously, the problem here is that we don't have a universal data bank of DNA, right? And all citizens haven't submitted DNA for analysis and subject to searching. Is that right?
Well, I wouldn't say that's a problem.
I wouldn't, but if you had that, you wouldn't be sitting here talking about familial searches and questions of the Constitution and statutory privileges and any of those things. Is that right?
Yes, sir.
Now, the same arguments that you've made for expanded use of the CODIS data bank, there are other data banks or potential data banks with DNA or DNA retrievable that could also be searched. Is that correct? Like the military
like
dimension,
hospital biopsy.
hospitals,
Yes.
Military data bank, all of those things, right?
To a degree. The military data bank is interesting, and it echoes a point that I think Barry is touching on, even if you didn't realize it, and that is the original intent of a collection may have one goal, but that could morph by statutory change. The military data bank, it's not a data bank, it's actually a board collections.
Right.
Was put there to identify soldiers or body parts of soldiers if they're killed in a training accident or in combat. Through the Culberson Amendment to the Defense Appropriation Act of 2002, the President signed that amendment that now allows federal judges and military judges to retrieve a blood spot card from me, for example, an officer in the Army, if I am suspected of a crime and if no other method to get my profile is available. If I flee the scene and move to Argentina and they wonder if I stole the Jeep or, God forbid, did something worse and my DNA is important, they can pull my blood spot card. Before that, there were uneven practices and there was nothing in the UCMJ, the Uniform Code of Military Justice Office. But through the Culberson Amendment, that's now open. That doesn't mean they can extract DNA from all the 5 million samples and upload it to CODIS, but theoretically speaking, Congress could pass it.
Well, there's no prescription against that, though, right?
Yes, at this point, you can't access those cards unless it's an identification, or in that instance where a federal judge or a military judge orders Sam Smith's card to be retrieved from Rockville. It has to be a one individualized suspicion, and it has to be there has to be no other way to get Sergeant Smith's sample from the file.
So, in other words, you felt that the guidance given to the holder of the blood samples was sufficiently clear that it couldn't be uploaded into CODIS right now, for example.
Yeah, the actual the military rules about collection and storage of those samples are very explicit.
So the same issues of public safety against civil liberties come into play with that database.
Except that database was obtained, it's not a database against the blood collection. That's there for the humanitarian identification of missing persons or victims of a war or something. It wasn't intended as a criminal investigation method like CODIS was.
It wasn't as a criminal identification method.
Correct.
But the body of blood samples that are there could prove useful in familial searches, right?
Certainly.
Right.
Yes. Yeah.
Well, if you want everybody's blood, you could go to the PKU heel stick cards, which are collected almost universally.
Right. All 50 states have statutes requiring a heel stick card, usually on day 2 or 3 for newborn babies, for mandatory genetic screening. The practices among the states varies widely about how long they retain those cards. We've actually gone back in cases. It was actually the Louise Woodward case.
Yep, I went and got it. But I went for court order.
Yeah, we went for court order. Yeah.
Even though I was worried they wouldn't ask for it.
But so there are instances where we have gone back with court orders, the blood spot cards, the heel stick cards, to do DNA testing for identifications and so on.
Fred, could you explain to us then exactly how you talked here about adventitious matches, a number of loci but not complete ones, right now in the CODIS system? Could you explain to us how that happens and what the CODIS rules are with respect to CODIS?
Well, the CODIS and this board, and I won't speak for Tom, and I hope I'm accurate in what I'm saying. My understanding is that the CODIS board does not prevent individual states from doing anything they want on their own or sharing that information with an adjoining state or neighboring state. I mean, Mitch Morrissey pushed that button recently in Colorado, who's the elected DA of Denver County, and has done some of these types of searches in Montana, Idaho, California, and Colorado, looking at doing investigations on crimes occurring in Colorado in his jurisdiction where he worries that the offender may be related to someone in one of the other states.
Could you explain how that works exactly? I mean, in other words, the district attorney in Colorado wants to do an investigation.
Yes.
Where he is doing a proxy search. So,
well, he may find
how would he do that?
So he's got blood on the sidewalk from the bank robbery, and it doesn't match anyone in the Colorado database. And he might wonder if it matches anyone closely in the Colorado database, and he might wonder if it matches anyone closely in the California database. So he could ask authorities in another jurisdiction to do a keyboard search on the profile he has from the blood spot. And is it a close match or a perfect? It's not a perfect match because he can search it on NDIS. He can search the whole national database. So
Or
a
say,
perfect match.
what
Change.
when you say that if you, well, what kind of a search is he doing? In other words, at what level of stringency is he looking? You presented data here about, is he looking for something that would restrict it to fathers? Or is he looking at something that, how do you define that? How is he defining it?
And let me say first what they do in Britain, because this is maybe helpful in our thinking about this. In Britain, they only use 10 loci, so they have 20 alleles in their profiles. Their threshold is 12. So when they've not found a perfect match, and they decide as part of a long process, 30-page manual on how they do this, they'll say, okay, give us a list of samples that match, that have 12 alleles out of 20 in common or more, between 12 and 19, right? If it matched to 20, they have a dime. So they then look at those, and maybe a long list, could be hundreds of samples, could be thousands of samples that match between 12 and 19. Most of them are not related at all to the real perpetrator, right? But because they share alleles in common in the population. You and I could share 10 alleles in common in our profiles, yet we're not related. So that's what I mean by adventitious match. They then narrow geographically. They screen Y chromosomes, which is what Mitch and others are doing, because males related by a common father, or maybe be father-son, will have the same Y profile. So they'll narrow it down that way. I have heard, and this is now hearsay, it's not admissible in your court, Gary, but that Charles Brenner has helped Mitch using kinship analysis in a case in Colorado that has been successful. I don't know any more detail than that, and I don't think this is a secret. It's talked about freely now in the forensic community. That they have rank ordered some samples as an experiment. This is hearsay.
But, and what do you mean by the adventitious instances where the law enforcement would adventitiously find out that there's somebody matched on?
Well, by adventitious match, I mean a false positive. You find samples that look like, gee, maybe they came from relatives, but in fact they don't. So let's say that there are only two people, all the males in this room are in this imaginary database, and here's crime scene evidence that, none of us did the crime, but one of our brothers did. They compare the profile of this crime scene evidence against that of all the males in this room, and they find 5 of us that share a lot in common. with that profile. So 4 out of 5 of us are adventitious matches. They're going to investigate your family and my family, and they'll find out you have 2 brothers and I have 3. And only one of my brothers is the real perpetrator. The other 3 would also be investigated because they're targeting all the 5 males in this room who have a profile that's fairly similar, not identical, but fairly similar. So the adventitious matches would refer not only to the people in CODIS, but to all their brothers who weren't involved.
With the list of
Is that-
speakers.
Maybe that term adventitious is confusing.
Well, you were referring something, let me try to help you here a little about what I mean and put it in legal terms, okay? Because it really does relate to the Fourth Amendment. If I have the right to search somebody's home, okay, I have a right to go in there, I may adventitiously, it's the word adventitious, see something in plain sight. And because I have a right to go just so far, if I see something in plain sight, I have a right under the Fourth Amendment to get it. Now, what I think actually happened in the Darrell Hunt case, and in lots of other cases, which is not problematic at all under our laws, and just in the analogy you give, if there's a blood stain here, we take everybody's DNA in the room, who voluntarily gives it because somehow it's related to criminal investigation, and by moving forward that way, we suddenly find that, there's 10 matches to Murphy, 10 out of 13 on Murphy, we'll go looking for the Murphys, and we get it that way, okay? That is far different, all right? And that term adventitious that way, I think is a good way to use the term, both scientifically and legally. And in many of these cases that Rock Harmon is complaining about and others, wouldn't it be true, and I'm just asking this, and maybe Nikki can help us, I think those arise when you're looking at mixtures, okay? You'll do what's known as a moderate strength search because you have a profile that has mixtures, and you adventitiously discover that there's somebody in the database that actually matches at a number of loci, and that's how you then go about focusing your investigation. And even that is much different, frankly, both constitutionally and in terms of policy, than deliberately going about querying the database and doing a proxy search at some level of kinship. Maybe
I can't comment on whether it's different constitutionally or not.
Well, I mean,
qualified to comment.
those are. Let's just keep those in mind as distinctions that I think are helpful, because
what
worries me about the way you've made this entire presentation, and you must know the truth. I don't. We've known each other a long time, and I respect you a great deal. You're not entirely neutral about this.
I said I'm trying.
I know you're trying. You're really not that neutral about it, and there are others who would express stronger civil liberties, morals, and I myself, might come out if we
You might have an opinion about it too.
Might rewrite everything a different way, but
Barry, what worries me is that this could save investigative time. How many white males did they pull over in the southern Louisiana case of the serial rapist? When they do DNA dragnets on Cape Cod, when the police had the guy sample all along, you know the case I'm talking about.
I know about all these cases. So I can tell you about the modalities. I can tell you about I sued them. And they still,
okay, time out though.
My point to you is simply this, that these distinctions are important, and there are others who have much stronger feelings about the civil liberties issues here than frankly I do. I'm probably, by comparison, a hawk, or you could design systems. The people that are selected to go talk to our DNA subcommittee on this issue, I would say out of all of them, Fred is the most in touch with the civil liberties issues, but I think leans in favor of this. The others are not representative of those concerns at all. And I would suggest that somebody like, for example, Sheldon Krimsky, who's about to write a book on this, in conjunction with, who's very in touch with the Civil Liberties Union, and others on these issues, should certainly be invited to our DNA subcommittee meeting. And there are some others. I mean,
All right, well, let me just stop right now. Excuse me a minute. And thank you very much for coming here, Dr. Berger, for a very enlightening presentation and for all the work that went into it. We really appreciate it, and you will be one of the people that we will call on to help us as we try to analyze these difficult issues in the months ahead. So I very much appreciate that. The DNA subcommittee is planning to meet on January 15th from 10 to 4 p.m. And I think the speakers are already scheduled for that meeting. It is in New York City. I'm not sure about the location, so we'll have to get information out to you. I will say in response to Barry that doesn't mean that they're the only people that we're going to hear about on the issue. So I think it's certainly behooves us to invite other speakers, particularly if you feel that all of the speakers that we have view it solely from a law enforcement angle and not from a civil liberties angle. But I'm not going to tell the DNA subcommittee who they should invite for their presentation. So they're going to have speakers and talk about these issues. You're all invited to be there. And I think as we move forward, one thing I want to make very clear is this is something that we have to study in great detail. There's no effort to direct us to make a quick decision in this area. I think it's important that we become educated and carefully consider all of these competing issues with respect to partial matches. And I'm committed to doing that, and I think all of you would want to do that as well. I appreciate the presentation, and I think it was very informative.
Commissioner, one question on the DNA subcommittee meeting. If we can't make that meeting, can we send a representative?
You can. I think it's an open meeting.
It's an open meeting.
The other thing is, I also can't make it, unfortunately. And we are going to both video it, and it will be webcast as well. I'm not happy that I can't be there either, and I've heard that a few other people can't be. But at the same time, we have, I understand, scheduled people that are difficult to get in one place at one time. So the meeting is scheduled on that date, but we will make it available to anyone who wants to view it. And we will certainly entertain other speakers and who we should hear from and invite them to the commission.
May make one, I hope, constructive suggestion in this regard. You actually said something during the course of the presentation about how many, what the numbers would be for minorities within a prison population if we extended the data bank to, I think you said, non-misdemeanors for collection or whatever.
Yeah, well.
One of the things I think would be extremely helpful, and this would involve criminologists or certainly DJCS could come up with it, I think we really need to know some of these statistics. I would not know off the top of my head, the racial composition or any other kind of breakdown of the New York State prison population or any of the categories of offenses. Because I think that Dr. Berger very usefully highlighted for us this issue that people do talk about a lot of genetic surveillance. I mean, it's very clear from his presentation that to the extent that something could be devised that would allow familial searching, it inevitably is going to perhaps create leads that might lead to people who committed crimes, and it will, by definition, lead to false leads. And the number one policy issue here has to do with genetic surveillance of communities and people of color. And if we could get some statistics that would inform that discussion, I think that would be extremely helpful, because to the extent that people will find out how big the net is, given different ways of doing proxy searches of the database, we have a better idea of what the prison population is or what the data bank population is. I think.
Well, I do think we have racial and ethnic breakdowns of the prison population, whether it's available for every year. For what period of time, I don't know. Otherwise,
Could we
you
get
know, I
that?
don't know.
Could we
So,
get
so
that
we
so
certainly
that,
can look and see what's available. I don't think Carrie's here, but I think we currently have breakdowns along racial and ethnic lines of our prison
The other thing is-
population.
the other
But
thing-
that's not necessarily the population in the DNA data bank, and I don't know that we have breakdowns along any racial or ethnic lines in terms of the entire
Well,
data
and I would
bank.
also say that the other very valuable set of data would be geography. In other words, where people come from that are in state prisons and in the database, because as Fred Bieber was pointing out, where this is heading is the UK system, arguably. I mean, what we're really talking about is doing familial searching to begin to target people that are related to each other within certain communities in order to solve crimes. That's what this whole enterprise is about. So to know what the impact of this is, it would be extremely helpful to have that kind of breakdown so that we're not just talking abstractly about the statistics. We would know if we go down, if anybody chooses to go down, whether this commission has the authority to do it or not, it's a separate and distinct question. But if the legislature or anyone else decides to go down this, it would be very helpful, I think, in policy terms, to know exactly what that's going to look like, given our present composition of the population. So if you could get those statistics,
Well,
I think that would help
well, I
us.
think you're a little ahead of where we're going here, but we certainly have statistics on the prison population where people are coming from whose DNA is in the data bank by county. I don't think there's anything that we would have.
There's no statistics
So-
on where people, either the county of conviction or the county of residence.
Well, I mean, you could do a huge undertaking project probably to determine that, but I think that's probably not the most pressing issue for us to undertake, given our limited resources right now.
Maybe we could discuss that, it wouldn't be so huge. But I would most respectfully say after this presentation that we just heard, that is exactly what this is about. And in no uncertain terms. And I'm not even saying it's wrong. I'm saying that's exactly what Fred proposed. That's exactly what they do in the United Kingdom. That is exactly the point of familial searching. To target families and neighborhoods, to see if relatives and people within a certain community committed the particular crime. That's
Okay. Our next item on our agenda is a report from the Office of the Inspector General related to the NYPD lab. It's an issue that we have discussed before here in the Commission, but not since the report was issued by the Inspector General. I just want to say by way of background, approximately a year ago when I joined the Commission, the most pressing issue was how we implement the Coverdale requirement that we have an outside body conduct these investigations. We had just started that, and I think we've come a long way during this year of devising both a process, a methodology, and I really want to thank the Inspector General for stepping up to the challenge because we have made a number of referrals and some of them, with respect to this case in particular, required an extensive investigation on their part. I really appreciate the professionalism, the quality of the investigation and the report. So I want to thank you. I also want to thank you for the efforts that are being undertaken with our labs, both to make our labs aware of the issues, aware of the fact that the IG does have jurisdiction over these matters if they involve serious allegations of misconduct that impact the integrity of the forensic results. And I think we've really made progress as a commission, in large part due to your involvement, Chris. So I really appreciate your office doing this. And I don't anticipate a lengthy discussion, but I would ask you and others, if you want them to participate from your office, to just summarize very briefly the report and to answer any questions that the commissioners may have. Yes, if you would, thanks.
Good afternoon. It's a very tough act to follow. I'm very glad I had the opportunity to see this very interesting discussion. Hopefully you've had the opportunity to see the report that we issued just recently. It was as a result of a member of this commission coming forward with what was really just some kind of rumor that was brought to the attention of John Hicks, who then did continue to investigate that just rumor. He went to Peter Pizzola, who is here today from the NYPD lab, to ask whether in fact there might have been some allegations of wrongdoing back in the NYPD lab in 2002. That began a preliminary investigation on behalf of the director of the NYPD lab, Peter Pizzola, into these allegations that we have now completed a report about. In very brief summary, what our report found was that there was an overheard conversation in April of 2002 in the NYPD lab where one chemist said to another that she believed that half the lab was not doing the appropriate testing on cases, particularly cases with many recovered vials or glassines. That did trigger some concern within the lab at the time and led to some proficiency tests of two of the two women who had been speaking to each other in this overheard conversation. Neither one of the women passed all of those proficiency tests. One failed two of them by coming up with false positives, which, as you know, is the most serious type of failure, where something that was not cocaine was actually said to be cocaine. The other also failed the test in the reverse manner. She said that something that was in fact cocaine was not, but in either case, neither one of the two women who had had this discussion passed the test. Unfortunately, not too much more was done within the lab to investigate these allegations, nor was much done with regard to the failures of these two women. ASCLAD was not notified at the time of the failures. The DA's offices were not notified of the failures. And later on in the year, another more routine proficiency test was given to one of the supervisors in the lab, and he also failed that test. Again, in the most serious manner, by reporting that something that was not cocaine was in fact cocaine. Again, that was not reported. I think the essence of our investigation, which was led by Kelly Donovan, my chief of investigations, who's here from my office, did an excellent job, and was written by Cheryl McCormick of my office, who did a lot of work around the statistics and the ASCLAD requirements that we had to become familiar with. I think that the most disturbing part of that was, though there was some steps made to investigate these troubling allegations, they were never really done in full fashion, and nor were the concerns revealed to the DAs or to this commission or to ASCLAD. I am happy to report, however, that the lab is a very different place today. Peter Pizzola and Vince Crispino and others from the lab worked with us very, very diligently. We spent many hours with them, with staff members, with retired members, both of the police department and chemists. We reviewed countless numbers of documents, rules, regulations. And though our findings were quite troubling about what happened in 2002, we believe that many of the shortcomings that we saw in 2002 have been rectified in the current way that the laboratory is conducting their tests, in the way that they have revealed other information that needs to be revealed to the DAs and to this commission and to ASCLAD. So though it was a very troubling report, I think the good news is that things are really in very good shape right at the moment. I wanted to say a little bit about the process. As I mentioned, we did a very extensive review, both of current and past employees of the police department, looked at all the paperwork. We also, as is our practice with all our reports, allowed the police department to review our report before it was made public. And we did that because we wanted to make sure that our facts were right. The police department did give us some comments. We adopted almost all of those comments. We, of course, reserve the right to make or not make the comments depending on what we feel that the investigation reveals. But we did think it was important to get their input. We did get that input before we released it to the public, and it is now what you've obviously seen. We, on a parallel course to this investigation, we are also conducting trainings. We have done one in Westchester County. I don't know if someone's here from Westchester. I believe that we will be out in the island shortly to do training with regard to what our office can do and the obligations to report to us. And we will be working our way through to all of your labs. We have customized training program to your issues, so though we do talk about the Inspector General's office, we try and gear it to the issues that we think will be of interest to the staff of the laboratories. So.
Chris, I know an issue was raised, it kind of left open last time and raised by Barry and I think Peter Neufeld about your jurisdiction over contract labs, and we had kind of left that open the last time. Could you address that issue?
I certainly can. I had, well, I guess would be understandable hesitation about the notion of the New York State IG investigating out-of-state laboratories. And I had some hesitancy. I must say, I've been looking at my statute, and with the months that I now have under my belt, I feel like I have a sort of better understanding of our jurisdiction or how far it can actually extend. And I believe that there is a good argument that we could do some work with regard to outsourced labs. There are some obvious restrictions that those of you who are lawyers here could understand, and those issues would involve our process. To what extent can our subpoenas be used? To what extent would an outsourced laboratory be willing to agree to our jurisdiction? So though I think we do have the right to look into it, the extent of our authority to do so is something that we would have to consider. It could also be, and I just throw that out, it's something that could be considered here, whether when an outsourced lab is hired, they could be required to accede to our jurisdiction. But these are things that I leave to you to decide. The other thing, I am the head of an agency, and I have said to Denise that, of course, there's a funding issue. I'm happy to say that since I've taken over, our caseload has tripled. We're doing tremendous amounts of work in many, many different areas of the state. So, though when I first began, I was very happy to take on this work, and I still am, but my caseload is constantly growing, and though Kelly is an unbelievably talented investigator, and Nelson Scheingold, who's here as my counsel, is as bright as they get, I don't want to burn him out too much, and I certainly wouldn't want to discourage them if I was sending them off to Texas to investigate laboratories far afield if I didn't ask for extra funding for that kind of thing. So forgive me for that request, but it is something that I have to mention, that I don't know to what extent our resources would accommodate something quite so far flung.
Before we get into any questions that anyone may have, and I know we have representatives from the NYPD lab here as well, if there are issues to be addressed, I just want to comment on a couple things. One, I know that after this came to light, Deputy Commissioner Phil Polanski was put in charge of the lab, and he's here with us today and has been attending our meetings, and I very much appreciate that. I've said it previously, but I think it took a lot of courage for the current leadership of the lab to come forward in this case, and I'm so glad that they did, and that we have people with their integrity at the lab. And I do think that we have seen that this is really a learning process in the labs, and the attention that is now focused by the Commission on these integrity issues, I think, is really being reflected in the labs and among the directors of the lab, and our meetings with the directors and their organization as well. So I do think a lot of good things have come out of what is unfortunately a very unfortunate experience to have occurred at the lab. One of the issues from my perspective on the Accreditation Commission is after a report is issued in a historical case that tells us that things have been rectified at the lab, but problems did occur, is to what extent was that considered by FCLAD labs, and is there follow-up work that we have to do as an Accreditation Commission? I know in this particular case, I did ask John Hicks to communicate with Accreditation Labs in particular about the NYPD lab in light of the Inspector General's report. And we did get a message back from them that, did you circulate, or is it in the packets?
I think it's in your package. It's an email message.
That basically said that they did consider the allegations in this investigation, the report, and the various serious matters that occurred at the lab in conjunction with their accreditation that they did under the new international standards in the report that we have issued here. So I think that's very important for us to make sure when we close out these matters, okay, that we know whether, when the accreditation process is going on, these matters are taken into consideration by Accreditation Labs, and in this case they were. I'd now like to open it to commissioners to see if you have questions for the Inspector General. Yes, Ira?
Yeah, well, first of all, I'd like to second your comments with respect to the excellence of this report and its commitment to bring to the public's attention the model response by NYPD to the problem as far as going forward. I do have some concerns, though, about a couple of issues that are in the report, which to me remain unanswered. And I don't know if they have anything to do within the jurisdiction of the Inspector General's office, so feel free to say it's not my job. Sure. The first, I think, is that the universe of cases that are being examined by NYPD is basically a year or two or a year and a half or something like that. And I don't understand why a problem that surfaced in the manner that it did surface, why it's felt that this is an issue that affected a year and a half, or whatever. In other words, maybe we ended the investigation at the end of 2001, and we started in 2000. It involves senior analysts, one of whom was a supervisor, different problems with each of them, let's say. I don't know why we have any reason to believe that these problems may not have gone back a little further, a lot further, whether the problem did extend to half the analysts or did not extend to half the analysts. In other words, what I'm saying is the universe of cases that are being examined as we speak today, I don't know whether that's sufficient. That's the first concern I have. The second concern I have deals with who do we notify. And I think that the process which is put into effect now, Coverdale notifying, I assume, specific VAs and specific offices if there is a problem, is going to go a long way in dealing with criminal justice aspects. But ultimately, if there's reason to question the accuracy of the lab report, it seems to me the judges and the accused need to be put on notice that there may have been a problem in a case that they were not made aware of. And to see whether or not they want to see any reason to test the correctness of the conviction based on reliance on perhaps a false report or an inaccurate report or not. It just seems to me that we've left the defendants and defense counsel and the judges out of the loop. And I recall the days of representing defendants in arraignments where one plea after the next was taken in low-level narcotics cases based on an absolute reliance on the accuracy of these reports. And if there's any reason to question that reliance, I think it could have a significant impact on the criminal justice system and needs to be addressed. Final concern was this issue with somebody who was denominated as Smith in your report, and also I'll have to deal with Patel, but this issue with Smith, I don't understand, Dr. Pizzola, why you're so convinced that there was a great scientific basis for concluding that what he had examined was cocaine, or cocaine was present. We have a series of microcrystal tests and color tests saying no. We have mass spectrometry saying no, and then we have a final test which might reveal a positive, based on cleaning of a cleaning out of a vial with a solution and picking up every trace from every corner of what have you of that vial. It just seems to me that I think that I wonder about that. So these are the things that kind of jumped out at me that came from the report, which are obviously portrayed in the report. And I don't know where, some of them relate to the police, some of them relate to who makes notification and to whom. But certainly, we're all much better off today than we were, let's say, in April, when there was some, two-liner in the New York Post, which may or may not have been read. So, I mean, I don't know whether, who wants to deal with any of these concerns.
Well, I can deal with some of them from my perspective. I think that as your investigative arm, I have to be careful to just remain an investigative arm and not a member of the commission. I think some of the questions you're raising are questions for the commission. I mean, they're policy questions, and I intentionally try to walk a line where we just did investigative work, regardless of what our personal opinion might be on these topics. I just don't feel that that is our role, and I don't want to lead into that role. And that is why we tried to keep it as tightly to an investigation as possible, and in fact tried to make it clear when we were not addressing an issue, though we knew the issue was there. So as to notifications, I don't think that's my province. If there's a question to investigate about that, I'm happy to do it, but the policy of it I don't see as mine. As to the question of John Smith in there, I don't want to go through all the details of the testing and what happened in that particular case, but we did look at it quite closely. We felt that, oddly, the lab almost acted too quickly and too harshly with him. He wasn't even allowed to finish his test before he was pulled, in stark contrast to how little they did later. And without going through the details of it, from what we had learned, we felt that the results that are in there would be our conclusion. And the third point, the number of tests to go back and test. Again, I almost see that as a question for the lab directors to answer. That might be a statistical question. It might be an analysis question that, again, I think is beyond our role as an investigator. I think that might be a question that one could ask anytime something like this arises, but I felt it was not what I was asked to do, and it might also be beyond my expertise. So that's me.
Thanks.
Yeah, the other thing I forgot to mention, Mr. Patel. I mean, Ivar Goldar, it's an unusual name. Patel is not, and I remember, I don't know how long this guy, his participation in this was sort of minimized because he was a supervisor and only did a limited number of tests.
Well, we didn't want to minimize the significance of the finding. The only thing we tried to be as factual as possible. We did a few cases. We did not want to minimize the fact that he flunked 2 tests.
Well, it was beyond that he flunked 2 tests. It was the manner in which that really wasn't as terrible to me as his explanation for why he flunked them.
Right.
Patel, according to Dr. Pizzola's letter to us, I think in July or June, remarkably offered him his defense. Patel did. I don't know whether you spoke to Patel.
We did speak to Patel. We spoke to. He said he was sloppy, and that is troublesome. But
well, I mean, he said he did not clean his test area, which meant his test area was contaminated from the moment he opened his first, let's say, glassine envelope. Thereafter, and conceivably, at that time, I'm sure they were working in the very close quarters. Other areas might have been contaminated by Patel's sloppiness. So he offered as his defense. In fact, he didn't dry lab. He just contaminated every test he did, which is a lovely way to defend yourself, but he did. If we accept that as being true, and I'm not sure I do, then significant problems flow from that. And I was very curious to know how many tests Patel did before he became a supervisor. Was he a long-standing member of the chemical analysis crew, and was he reasonably promoted? Because I seem to remember cross-examining this guy in the 70s. I mean, I may be wrong about that.
Patel is a very common name.
Yeah, it's a common name, but I'm concerned that he didn't arrive there as a supervisor doing 30 tests a year. That he arrived, and again, this goes back to the issue of how far back we go. I have no way of answering that question. But that was.
Okay, just Superintendent, did you have a question, or was it answered?
No, I'm done.
It was
I mean, so
answered.
Patel was a separate issue, and if I look at Patel and I look at Smith, I don't agree that Smith was pulled off the case too early. I think he was pulled off exactly at the right time. And I have to agree.
No, I was talking about Smith,
Yeah.
not Patel.
Oh, I'm sorry, Smith.
Right.
Yeah, Smith. So, I mean,
And he might have
perhaps,
been,
yeah.
but I didn't say it was too early. I was just saying that they moved in very quickly in one instance without even allowing the chemist to finish the test and reacted quite differently in others.
Yeah, at least, yeah. Well, maybe Dr. Pizzola would like to speak to that.
Superintendent?
Christine, having read the report, I want to congratulate your office on doing an outstanding job in this investigation. But the one question that really, I think, as a police officer, to ask here is the role of IAB, because it appears by your investigation that NYPD IAB didn't do work on this. And do you think it's important that these types of cases be brought to IAB and that they take them and run with them, or are we in a situation where we suspect this type of misconduct and we automatically go to Chris with it?
I can speak to what we found in our report, and we stated it in the report. We believe that all the parties underestimated or did not appreciate the seriousness of what had happened. And clearly, IAB did not conduct an investigation. That raises another question, and again, that might be something for this commission. Is IAB the right party to do such an investigation? Because it really is one of science. There's an integrity component to it, but many of these questions, as you can see from our report, are based on science. And I think we now have a situation where Vince Crispino, who's the integrity officer of the lab now, has a scientific background. I presume he would be the one to do the investigation, but I can't speak to that specifically. But clearly, at the time, it did not appear that there was a sufficient appreciation of the seriousness of the findings. And certainly IAB did not seem to have that.
I think the other issue is that it appeared to have been a problem that, at least in the minds of some lab directors, that if there was an internal affairs investigation that relieved them of the responsibility to report to ASCLD labs or to answer questions accurately about whether individuals failed proficiency tests. I think we've made it clear that that does not relieve them of their responsibility to provide truthful answers to the accrediting body and to report to us. And to the extent that people harbored under that kind of confusion, I know that can make internal affairs investigations more difficult, particularly if they're confidential. But as far as they relate to reportable conduct, those reports have to be made. So any other questions for Chris?
This is on the issue of contract labs, so.
I just had a few. And first, let me also say that I think it's an excellent job, and it's exactly what we had in mind. And I think I don't want to cast invidious comparisons, but I think that looking at this report and comparing it to the one we got from the State Crime Commission, I think it shows the wisdom of having put you in charge of this. I have one question on Patel, just as a follow-up. If in fact there were these contaminations, what happened to those cases? In other words, all the cases how many cases did he do, and what kind of notifications
His defense
were made?
to his one failure was contamination. He didn't speak to any others, and as we noted in the report, the difficulty of looking at facts from 2002 in 2007 is that it renders it virtually impossible to investigate these very issues.
Right. No, I appreciate that, but strangely, if you accept his defense as accurate, that he wasn't dry labbing, he contaminated his instruments, then the implication of that is that there has to be notification for all cases he did within a certain period to the district attorney's office, courts, the defense, because in some ways that's one where that's a better basis, frankly, for questioning a conviction, strangely enough, than this notion of dry labbing, which may be impossible to investigate.
I would take both of them as serious. We found no actual evidence of that, so we just wanted to be evidence-based. That one could draw those conclusions, one could ask those questions. We didn't find any evidence of it, so we couldn't report it. I just don't know what to, if Patel said that's his defense, that's what he said, but it wasn't that we found any other evidence of that. And we really had no way of finding out one way or the other. It was not something we could resolve.
I guess what my suggestion is that how many cases did he do within the period where he reported that he had contaminated his workplace?
His claim was it was just that one case.
Or just that one case?
Yes, right. He wasn't saying, I think he was trying to come up with a defense for his one case, and wasn't going to be so foolish as to say, I'm always doing it.
Second thing.
I think we were told initially that was his practice.
The second thing I was curious about, and I couldn't quite figure it out, that you indicated that the proficiency tests that were done within the lab were blind, right?
They did many different kinds of proficiency tests, but the two that went to the women who had this conversation about half the lab, those were blind. The one that went to Patel that he flunked was blind, meaning that they did not know it was not a real case.
Right. And what struck me is that, gee, that seems like a pretty good thing to do. Did you find any evidence that it was of insuperable difficulty to do a blind test like that in the context of the lab?
It's not a difficult thing to do, but there is a discussion in our report about the wisdom of doing blind testing versus non-blind testing. Blind testing, if you don't tell the chemist or the lab that they've made a mistake, you don't correct their behavior. Non-blind testing, where the chemist learns that they've made a mistake, the whole lab is retrained, might have a more advantageous effect in the future. Here, they did blind testing, the chemists did not know they'd made a mistake, and were not retrained.
Wait a second.
We could talk about testing though at a different time, but I'd rather just.
But they do it in many different ways now, which is good, so you have the best of all the variations.
But really, when you say you could do a blind test and identify mistakes and then change them and have people remediated for
yes, you could
train.
Absolutely.
But yeah. I guess the point I'm making is that the blind test discovered what appeared to be dry lab. So it was particularly effective and didn't appear that hard to do.
These were directed blind tests. They directed these tests to the two chemists because of their conversation.
I understand, but I guess my point is that if you did blind testing, and made sure that everybody in the lab was blindly tested, that's something that can be done.
Right.
And one of the things that comes out of this report is that it's very revealing as to serious problems.
Right, and I believe Pete does it now, right? You do blind testing now.
Yes, we do.
Yeah, they still do.
Okay, so I just know we have 4 other items on the agenda, so I know that the whole testing issue is important to us. Yes, Dr. Willie?
The contract lab issue, we've discussed this before, that in light of, yes, there's jurisdiction, but it might be problematic. We had discussed whether or not an instruction or letter from yourself to the labs, the DCJS accredited labs, informing them that if they enter into contract with outside laboratories, they should include in their contract language the fact that by accepting a contract, that laboratory becomes subject to and submits to the jurisdiction of New York State's delegated investigative agency. That will help resolve the issue of whether or not they would submit.
It's a very good point. We did that with all our New York State labs, but we didn't do it regarding the contract labs. I don't believe that was part of the letter.
But I think the way to do it is to go through the New York State labs, and if you contract, and that means if you send a single set of samples and ask someone else to do them for you, you need to have this contract language that says
that they are agreeing to jurisdiction.
I second that motion.
I would also.
Is it only the labs that is contracting stuff out, or are police departments also contracting out of state?
I don't know if police do, but I don't know if we have jurisdiction over that.
Over the labs. So I will accept that as a motion and a second. Is there any other discussion? Okay, all in favor?
Aye.
All right. Okay, would you please make a note of that? All right. Thank you very much. I really appreciate it. And the next item on our agenda is laboratory annual reporting by Catherine Levine.
At the last meeting, we handed out I did a PowerPoint presentation on laboratory annual reporting and case for QA procedures. And at that meeting, we handed out the chart with and accompanying documentation for the 20607 laboratory annual reporting.
Okay.
And since you hadn't had time to review any of that at the October meeting, we were put this on the agenda for today to discuss any further issues. Also during that meeting, we were asked to provide the raw data for the presentation, a PowerPoint presentation. And in November 7th, a letter went out to all commission members with 5 charts. I'm assuming you all got that information. We have additional copies here if you need them.
There also was a letter of December 11th from the Innocence Project requesting additional information, and Catherine is gathering the information that is available. It's not everything, but there is information that is available to answer a number of the issues that are raised here, and we'll get that out to you, and you can get back to us and let us know what else is needed. I just want to kind of make one suggestion about the requests. The document production is really coming from the labs, and Catherine is a person who works for us and tries to support the commission and tries to gather the information, but they're really not production requests to her. She doesn't have the data in most cases to respond. She has to go to the labs to get the data. So we do have to make sure that we're asking for the most pressing data because we don't have an unlimited ability to do it. So I'd like it to be focused on what you think is the most important information. But we'll get that information out to you, and anything that we'll get out to all the commission members. Catherine, you want to continue?
The other issues, 2 issues from the annual reporting were brought up to us in the letter, December 11th letter, and that was the further information on the email attachment from the corrective action it was the New York City OCME forensic biology, and it was regarding the corrective action regarding voting technology. And we do have that email attachment now, which is being handed out. So that was requested. And the other issue in that letter was regarding the CODIS issue at the New York City Office of the Chief Medical Examiner. And we do have representatives from that lab here, as well as, John, did you want to speak to that issue? Or
Okay.
Did you want to speak to the CODIS issue, or do you want?
Well, I could speak to it, and if I misstated it all, Ray Samples is here, but there's one question that was raised in the letter about the CODIS problem, sort of in quotes there. And as I understand it, this issue involves if you have series of crimes, so for example, a series of rape cases, typically when a DNA profile is then recovered from the evidence that presumed perpetrator of the rape, that profile is sent up to the state index system for comparison with offenders and other cases. And then if subsequently there's another 1, 2, or 3 or 4 additional rape cases that are determined at that laboratory to be the same perpetrator is being recovered, they don't send each new sample up to the Estes because that would just result in repeated matches each time it's searched, and because those data are searched against the other every time a search is done as well. So it's only one profile. And apparently in this instance, the laboratory determined that in a couple of cases that they had the pattern of associated rape cases, for example, but they had determined that the single profile from one of those cases had not been passed up to Estes at a timely basis, so it wasn't being searched against the state index. So that was, it appears to me, an oversight. I don't know if there's another characterization, but they detected that in their review process, and they tried to put in place procedures to correct for that and be sure that doesn't happen again.
My question about that is, why wouldn't you put all of them in? I mean, because that way you wouldn't miss a case.
Well, this is a practice nationally, to my knowledge, that because each time then you have these cases, the searches are done and it continues to be pinged on one another, you'd be generating continuous reports of these matches. You'd be seeing them every time you did a search, and it would just, it ends up being cumbersome and inefficient to try to deal with it. You're really looking for the linkage between your case and perhaps a different jurisdiction. So if that rapist moved to a different jurisdiction and a sample was uploaded, then of course that would provide you the match that would be helpful information to follow up on. But when you're already handling those cases within your own jurisdiction, that information is already being communicated to the police anyway, so that you've got these linkages of cases. I don't know if that's a fair characterization, or if you want to comment on it, or?
So the failure here was that, as I understood it, there was some numbers, like 6 cases in a pattern. One profile was put into the ENDIS system, and for some reason when something came back and was a hit, or one of the other pattern cases was missed. Is that it?
No, we failed to put up even a single example into estimates through a process failure in the laboratory that we identified. So none of them had been uploaded. One of them should have been. It was 7 patterns that were.
So in other words, in the pattern cases, you just upload one profile.
Correct.
And there was an assumption that one was already in there or something.
Okay, Catherine?
Okay, so I don't have any other issues that I know about from the annual reporting unless you have had time to look at that charts and you have issues and we can try to address those.
Thank you. Okay, Harvey Van Hoven has agreed to undertake an inquiry or project for us. And Harvey, would you talk about your project?
Well, there's been some discussion at some of the previous meetings about the educational and training requirements that some of the forensic examiners around the state have, and the question of whether those are adequate or not for the examinations that they should be doing. And so I thought it would be in the best interest of the laboratories and the commission and forensic science in general in New York State that if this was evaluated and looked at, to actually see if what we have in place is adequate or if it's not. And one way of doing this would be to work through, what I propose anyway, is working through NICLAC as the organization to take this on, to look at each of the laboratories. Each of the twigs could look at the requirements that they are required to have to do the analysis, because if they are the people actually doing the casework, they have a good idea of what is needed to do that particular type of analysis. And also the lab directors need to be involved, because some of the requirements for different people do affect the hiring and retaining of different analysts. Also, the law enforcement and the judicial areas, both the prosecutor and defense attorneys, there's certain requirements of analysts that are needed to allow someone to be declared an expert in court too. So all these different organizations have a stake in this as to whether the education and training requirements are adequate for the forensic examiners in New York State. And the proposal basically is that NICLAC will undertake this project and then make recommendations back to the commission.
I think it would be very helpful. I know it's come up at various meetings that we've had, particularly the entry-level positions or the positions that historically have been filled by developing expertise in the field. That may be the best way to do it. It may not. I do know civil service rules come into play too, and some of these positions, so that's a big piece of it as well. It's not all within our control. But I think it would be helpful to hear from the labs themselves, and the labs take a look at it and then report your findings to us to consider. I think could be very helpful. So I appreciate you undertaking that responsibility, and if we can help in any way here in John's office, please let us know. And Kathleen Corrado, I also understand, Kathleen, that you've agreed to assist in looking at use of reanalysis techniques, which was the subject of our meeting, commission meeting last time, and has repeatedly come up.
On my watch. I apologize for being the last person on the agenda because I know some people have to catch trains, and I won't be offended if you need to leave. As the commissioner said at the last meeting we were at, we talked about a couple of different ways of enhancing our quality assurance systems in the lab, and one of the suggestions was reanalysis of casework. So what I was going to do is just define a little bit what we mean by reanalysis of casework, and after the last meeting, at the NICLAC meeting, the lab directors meeting, we actually brought this issue up and we talked about it and talked about, are some labs doing this? What are some of the issues that are involved? There's a lot of logistical issues that have to be looked at prior to implementing a reanalysis. There's a lot of factors that come into play. So I thought I would talk a little bit about a few of those, just to give you an idea of what we're discussing at the NICLAC meeting. And the idea would be that we'll hopefully set up a working group to look more into these. But basically, what we're talking about in reanalysis of casework is actually having a second examiner repeat the entire analysis. So they're actually generating new data and reinterpreting those data and coming to their own conclusion. Reanalysis would be just another element of the quality assurance system. It would not replace proficiency testing. It would not replace audits. It would not replace tech review or verifications. I actually talked to a couple people about this. When you think about what the purpose is of a reanalysis, it's not really as clear as you might think. I believe the purpose would be to verify the competence of the first examiner, because the second examiner will know what the first examiner's results were, basically, because if you're reanalyzing evidence, you can see what's written on it and that kind of thing. But the first examiner, when they're doing the case initially, doesn't know what's going to be chosen for reexamination, so they wouldn't really know that it's kind of a blind test on the first examiner, basically. What you're hoping to gain, I suppose, by looking at reanalysis is, your proficiency testing and your quality assurance measures are going to check the accuracy of your system and your quality assurance. I think what you're really looking at is something that could be missed by those other processes. Is there an examiner that perhaps is missing evidence? Is there an examiner that's being unethical, that's maliciously not reporting something, or is dry labbing or something to that effect? So basically what we're hoping to do with reanalysis is just to look at the competence of the first examiner and try to catch something that might be missed in our other programs. Some of the issues that we talked about are, I was talking to John Hicks about this recently. When you first think about it, you go, well, just reanalyze the case. It's really no big deal. But you have to think about the ramifications of that. And you can't just say we're going to do random reanalysis and just choose any case, because certain cases we have certain issues with. For instance, you don't want to pick a large case that has 100 samples that's going to take someone a lot of time. You have consumption issues. You have in the biology or the toxicology or the trace areas. If there's a limited sample, you obviously don't want to reanalyze that because you want to leave sample for defense testing if necessary. You have trial date issues. You don't want to start a reanalysis the week before it's going to trial, and you don't even tell the judge, we're in the middle of this reanalysis, so you have to delay trial, and you can't really do that. So those are things that we need to think about. The other thing we need to think about is the reporting of the results, I think, because the question is, would you do the reanalysis before the first report went out, or would you do it after? If you have a first report out, would you just say this case was reanalyzed and the results of the second examiner were consistent with the first, or would you actually type a whole second report? And would you be obligated to? For instance, if a sampling issue occurred, if in a DNA case you had a mixture or something where the first examiner got 12 loci and the second examiner got 13 just because of a sampling issue, I would think we'd be obligated to report the second one because they're both accurate findings for that result. So I think you have to ask yourself, how would you go about doing that? The other issues are frequency issues. Are we talking one case per analyst per year? Or are you talking 10% of all your cases? Where do you get the benefit versus the drain on your resources for doing too much of that? So those are kind of some of the things we talked about. And I think what we were hoping to do
would be to set up a committee that was made up of lab directors, quality assurance managers, and obviously some of the technical people that work in the different disciplines, because each discipline is going to have its own issue. And have a working group set up to look at these issues, maybe come up with more, contact other laboratories either within our state or in other states that are doing reanalysis programs and get kind of best practice and come up with guidelines. Because I think before you implement this, you have to think about these things ahead of time and make sure you know what you're doing before you go ahead and implement it. So our goal would be to work through NICLAC to set up a working committee to work on these issues and hopefully report back to you with what our findings are.
Well, I think that's an excellent report about all the possible problems, and I think they're real, and I think that what I would commend your attention and ask you to think about is the comparative utility and value of blind testing, particularly external blind testing. And to give some history on this, I feel like I'm, with Fred here and everything. I mean, these things have gone back to the 80s, and 90s. But from some historical background is that in 1992, when the DNA Identification Act passed Congress, there was a provision in there that indicated that laboratories should engage in external blind proficiency testing on samples that replicate casework. Basically, there was a special committee that was set up to examine that issue because there was a strong feeling in Congress then, and it was also a recommendation in the 1992 National Research Council report on DNA technology and forensic science. And it's been an issue that's, I think the laboratories are really going to be in a position now to take on. And that is, the debate was, if you do external blind proficiency testing on samples that replicate casework, that is the best possible test of the entire system. All the way through, every step of the way, from the sample handling to the analysis, you really get a good result from that. In addition, it has the tremendous value, in the judgment of many, of being a deterrent. And I can't think of a better example than what the New York City Police Department showed in this drug analysis. I mean, how many more reports do we need? If people in a laboratory know, in the narcotics laboratory, that they're going to be blind tests, just like the ones that were administered in New York, then, the danger that they're only going to analyze 38 bags of cocaine and not all 40 is to some extent minimized. So the whole issue of reexamination, to give you some historical context, was an answer from some in the forensics community, and this was a particular report that was issued by Gansler and Peterson, and I was a member of it, and a fellow named Bill Thompson, and we dissented from it. But reexamination was said to be the check that would be a substitute for external blind proficiency testing. And I just think external blind proficiency testing, or even internal blinds, are a far superior quality assurance method. And in particular, as our friend in Nassau County has pointed out, I think certain disciplines are more susceptible to it than others. Obviously, in the analysis of drugs, I think it's comparatively simple. In fingerprints, I think it's comparatively simple. Could be also for ballistics, which is a troublesome discipline where we're seeing a lot of problems in our proficiency tests and our reports. We've seen it in all three: ballistics, fingerprints, and narcotics analysis. All three of those, I think, you can do the blinded testing. So I would really ask you to think about that as some kind of a substitute for reanalysis.
Could I just ask Dr.
Well, I think, Barrett, we need to be real clear that the testing that's being done at the New York Police Lab is internal, blinded challenge. It's not proficiency testing. It's not an externally graded assessment. And in effect, it is reanalysis, because those blinded samples provided to those analysts were reanalysis of materials available to that laboratory. I think, as Dr. Grotto has pointed out, this reanalysis in effect is blinded since the first analyst didn't know this case was going to get reevaluated, it's a blind evaluation of the quality of the first analyst. It could be structured to be a blind analysis of your second analyst. And, and I don't know how difficult that would be, because you would have to somehow delete from the case materials the previous analysis, and I don't, because you're in chain of custody and where things get put.
It's problematic.
It's problematic, but obviously it worked for the drug testing that was done in New York City.
Wait a second, let's just talk. We may be calling the same thing by different names, but
I think that's a potential problem.
But let's be clear about it. I mean, you can have an internal test that's blind. The analyst doesn't know that he or she is being tested, and it's on a set of manufactured case materials. It's internal if the lab does it itself. It's external if somebody else designs the materials, and everyone in the lab doesn't know that they're getting a constructed case. Now, whether it's an internal blind or an external blind, it seems to me that it's a better and cleaner test in many ways than these re-examinations, which create all these legal problems that you pointed out.
But Barry, I disagree, because I think the issue is that the caveats that I can bring up with reanalysis, I can give you the same number of caveats with PT, blind PT. And so there's an issue of neither one is going to be perfect. And I tell you, my opinion, not the opinion of the NICLAC, is that reanalysis of casework is much more feasible in the long run than blind proficiency testing. And I think they have the same effect. The deterrent effect is still there. And the fact that it's blind for the first person, possibly for the second person, I don't see that there's any benefit to one or the other. I think the re-examination is much more feasible, in my opinion, than the blind.
Because you don't have to manufacture the materials for the most part.
There's no question that the forensic community has long maintained that re-examination is more feasible, and that's why this was put into the accreditation requirements as opposed to internal blinds or external blinds. But I mean, just from the point of view of people who try cases in courts, I mean, if you're going to do a re-examination and you're going to get a different result than you got at the time of the trial, that's a problem on our end. I mean, I understand that it's a little, you may think it's harder to do the blinds, but I just think our experience here shows that the blinded testing has some really good results, and in certain disciplines, how hard can it be to do it in fingerprints, narcotics, and ballistics, just to start with? How hard can that be?
It is hard.
Okay, I'll just, I know, John, you have a view on it, and then I want to wrap it up to give people at their trains.
Well, just a couple of observations. The report that you referred to in the 1992, of course, I know you dissented from that report, but I think you were arguing the reason that the legislation even included that provision that this be studied and assessed by this independent group, it was because of your arguments, and that group came back and I think had the same response that we're hearing today for that. The other point, I think, which was made earlier, and that is that where we have detected these problems in the NYPD lab, in the OCME lab, there was an issue a couple of years ago on an analyst failing to implement controls. The FBI lab had an issue 3 years or so, whenever that was, on the DNA analyst failing to implement. All of those came to light based on observation by another employee in the lab. So it really becomes it wasn't detected through proficiency testing or something else. It was detected through technical reviews and observation by other employees in the lab and just exercising their ethical standard that they applied in that. So there's no evidence that I'm aware of where blind testing has been shown to be an efficient way of detecting these kinds of problems. The NYPD blind test was specifically contrived after they had information that there was a problem, and it was structured in such a way to detect that.
Well, some very good points have been made, so I think we're going to wrap up the discussion.
I would just ask you to consider the blinds.
And I think it's a great project for you to undertake. So I appreciate your willingness to undertake the project as well. Anything else we forgot on the agenda?
It's not on
Dr.
the
Willie?
agenda, but before we set the agenda, I would like to make a plea to commission members and to the office that if we don't receive the documents 10 days prior to the scheduled meeting. They should not be on the agenda for discussion. It's just way too much
confusing.
stuff coming the day before a meeting, and it makes it, with all of our other obligations, and I believe under the public meeting rule, the agenda and the materials have to be made available at least 7 days. I'm just saying 10 days gives us a working week. So that's just.
Okay, no, we'll follow that, and I know Barry and Peter and I are getting better about giving us their requests earlier, but that means we're not going to be responding to them until the next meeting unless we get them early on. So that's where most of the requests come, and from anybody else. So a lot of this, actually, John and Catherine do a great job setting the agenda, getting everything out, and then we get a lot of last-minute requests that we're trying to respond to. So, Ivor?
Just in a new business, I mean, not to be discussed today, obviously, but I'd like sometime in the future, commissions to discuss post report on Coverdale referrals, whether or not we feel that there's further obligation to notify affected parties of possible problems with the criminal justice system, just sometime in the future.
Okay, definitely.
Thank you.
And I appreciate that. If you have items you want on the agenda, if you can let us know. That way we can line people up to address them. I wish everyone a very happy and peaceful holiday, and thank you very much for all of your input and attention and all the work that went into the meeting. Did we set the next meeting? I don't think we set the date, right? No.
Thank you. Yeah.